Good morning, everyone. Joe Maestas here. Everybody doing okay?
Yes, Mr. Chairman.
That's not him.
And how are you, Mr. Chairman? Since I'm
Doing
the only
great,
one
Russell.
responding. Sorry.
All right, everyone. Good morning. It's 9:30 a.m. I want to welcome everyone to the regular weekly meeting of the New Mexico Public Regulation Commission. I'd like to call this meeting to order. Judy, roll call, please.
Actually, Mr. Chairman, I will be sitting in the general counsel seat this week. Judy and I have been trading off week by week.
Okay, sounds good, Russell. Proceed, please.
Commissioner Hall,
Present.
Commissioner Vicente Aguilar,
Here.
Commissioner Fishman, Commissioner Fishman, Mr. Chairman,
I'm here.
and Commissioner Byrd.
I'm a present.
Mr. Chairman, we have 4 commissioners present, which is more than a quorum, so the meeting may proceed.
All right, thank you, Russell. Let's move on to the next agenda item, to the Pledge of Allegiance and the State Pledge. All rise, those of you in the hearing room. Commissioner Byrd will lead us.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. I salute the flag of the state of New Mexico and the Zia symbol of perfect friendship among united cultures.
Thank you, Commissioner Byrd. Thank you, everyone. All right, members of the commission, you have the agenda before you. Are there any changes to the agenda? I have one potential change, but I want to hear from other commissioners if they have any suggested changes. Any changes at all? All right, I would like to move executive session to the end of the agenda. This is regarding personnel matters, so it would be, if there's no objection, right before adjournment. And that's if we need it. Are there any objections to moving executive closed session to near the end of the agenda? There's still a discussion to come regarding, whether to go forward with this executive session. We had intended to conduct interviews for an open and advertised advisory economist position, but we apparently are not ready to shortlist the number of candidates and prepare for interviews. So we may have to conduct the interviews at the next meeting. And in that intervening time, and even at this meeting, if the commission desires to go into executive session as a means to shortlist the candidates, we can do that. So let's keep executive session on. Let's move it to the end of the agenda. However, we may not be conducting interviews as we've only had one candidate available on such a short notice to be interviewed by the full commission. So if there's no objections, do I hear a motion to approve the agenda as amended?
So moved.
Okay, we have a
Mr.
motion on the
Chairman.
floor by Vice Chair Hall. Is there a second?
Mr. Chairman,
I'll second that. Under discussion, Commissioner Vicente Aguilar.
yes, thank you, Mr. Chairman. It seems very difficult to focus on the candidates for the position that's, that we're talking about, for the advisory economist position. I don't understand why, we put it on the agenda. This happened twice this year. I think HR matters should be a Zoom call separately away from the open meeting. The only time that we announce a new person that we want to hire, that's when we put it on the agenda, when we are prepared. And I don't like the way things are running right now. The other concern I have, Mr. Chairman, is that I'm not sure if HR employees have informed the candidates that this position is exempt, and more likely that by the end of this year, there's going to be changes, major changes, and people living in the East Coast, are they going to move to Santa Fe? If they are offered a job and then they're only here for 6 or 7 months and then they're without a job. I don't like the way it is set up for now, but I would like to have, an opportunity for the commissioners to think about the process. I think we should do the interviews a different day on a Zoom call. That's my suggestion, and I appreciate your time. Thank you.
Thank you, Commissioner. And I'm sure the candidates are aware that this is an at-will or exempt position. But certainly we can discuss the process some more if we choose to go into executive session later on in this agenda. If not, we can just simply defer it. And in that intervening time between this meeting and the next, we can, maybe come to some consensus in terms of what the short list is of these candidates, or we interview all the candidates that meet the minimum qualifications. So let's leave our options open at this point and consider the executive session when we get to it. Thank you, Commissioner Vicente Aguilar. Any further discussion on the motion to amend the agenda or to approve the agenda as amended? Any further discussion? Russell, roll call vote, please.
Commissioner Byrd,
Aye.
Commissioner Fishman. Commissioner
Aye.
Fishman,
Aye.
Commissioner Vicente Aguilar,
Aye.
Commissioner Hall,
Aye.
and Mr. Chairman.
Aye.
Mr. Chairman, the vote is unanimous to approve the agenda as amended.
Thank you. I don't believe we have any special guests or members of the public that wish to make comments to the commission. Isaac, can you confirm?
Yes, Mr. Chair, there's no one signed up for public comment, and I am not aware of any special guests.
Okay, let's go ahead and move on to item 7, consideration and approval of prior meeting minutes. Members of the commission, you have the minutes of the May 4th, 2022 open meeting. Do I hear a motion to approve as presented?
So moved.
Okay, we have a motion by Commissioner Byrd. Do I hear a second?
Second.
Second by Vice Chair Hall. Any discussion on the motion? Okay, hearing none. Russell, roll call vote, please.
Commissioner Vicente Aguilar,
Aye.
Commissioner Byrd,
Aye.
Commissioner Hall,
Aye.
Mr. Chairman,
Aye.
and Commissioner Fishman.
Aye.
Mr. Chairman, the minutes are approved unanimously.
Okay, let's go ahead and move on to the consent action items. There were no amendments to the consent agenda. So do I hear a motion to approve the consent agenda as presented?
So moved.
Motion to approve.
Motion by Vice Chair Hall and a second by Commissioner Byrd. Any discussion on the motion? Okay, hearing none. Roll call vote. Russell.
And Mr. Chairman, I will read the docket.
Oh, yes,
title.
yes, please do.
Okay, so the consent action agenda items are first, docket number 22-00001-TR-EN. That's in the matter of the revocation of operating authorities for failure to comply with financial responsibility requirements. New Mexico Public Regulation Commission Transportation Division versus We Care Transportation LLC et al. This is for a potential order regarding motion to continue proceedings. The second item is docket number 22-00083-TR-M. That's in the matter of the application of Albuquerque International Balloon Fiesta, Inc. for declaration of a transportation emergency pursuant to the Emergency Transportation Act. That's for a potential order regarding application. Among the utility matters, we have docket number 20-00241-UT in the matter of El Paso Electric Company's application for approval of its transportation electrification plan for 2021 through 2022. That's for a potential order regarding the revised outreach plan. We have docket number 22-00075-UT. That's in the matter of Public Service Company of New Mexico's application for authorizations pertaining to the proposed amendment of its $400 million revolving credit facility and proposed amendment of its $40 million local bank revolving credit facility. That's for a potential order regarding recommended decision. And finally, we have docket number 22-00095-UT. This is in the matter of the application of CNS Networks LLC for a certificate of registration to provide competitive local exchange service in the state of New Mexico. That's for a potential order regarding application for certificate. Those are the consent action agenda items. And now I will take the roll. I would take the roll call vote. Commissioner Fishman.
Aye.
Commissioner Byrd.
Aye.
Mr. Chairman.
Aye.
Commissioner Vicente Aguilar.
Aye.
And Commissioner Hall.
Aye.
Mr. Chairman, the consent action agenda items are approved unanimously.
Okay, thank you, Russell. Let's move on to regular action items. We don't have any under transportation, but we do under utility matters. In the case of 18-383-UT, in the matter of a filing of advice notice number 69 by Socorro Electric Cooperative, we will be taking action on a potential order on a stipulation. Miss Judy Amer, take it away. Judy, are you there? I think you're on mute.
Yes, thank you. Good morning, Mr. Chair and members of the commission. This matter comes before you today upon our May 4th order, which adopted Socorro Electric and staff's compromise. The May 4th order required within 7 days that staff and Socorro Electric shall sign an agreement containing the terms of the proposed compromise that was set forth in staff and SEC's pleadings, and also required within 7 days of the order to file an advice notice containing the rates required by the final order, subject to staff's approval, which shall be filed within 5 days. And within 30 days of the order, Socorro Electric shall implement the rates in the filed advice notice, contingent on staff's approval, and contingent upon staff and SEC jointly filing a notice of compliance with the written compromise within 45 days of this order, the revised order is stayed until the Supreme Court of New Mexico issues an order and mandate in the appeal of the final order. Therefore, in compliance with the May 4th order, on May 9th, Socorro Electric filed advice notice 72. Attached were all of their rates, and that was provided in your packet, the advice notice. And we still haven't received staff's notice of approval of the advice notice. But on May 11th, 2022, in accordance with the May 4th order, a written stipulation was filed and signed by counsel for staff and SEC. And the important parts of the stipulation are quoted in the order, and they agree to immediately implement the rates adopted in the September 11th, 2019 final order. SEC agrees to track all rate changes ordered by the commission in the final order since September 11th, 2019. And if Socorro Electric is unsuccessful in the rate case appeal, it agrees to adjust the amounts of those customers affected by the rate changes during the period of time to be determined. SEC agrees to withdraw its appeal of the April 2020 compliance order and its appeal of the March 30th revised March 30th, 2022 revised compliance order, and agrees to withdraw its motion to stay and its 2 petitions for writs before the New Mexico Supreme Court. SEC is not required to withdraw its appeal of the actual final order. As I have indicated previously, that appeal has been fully briefed before the Supreme Court, and the Supreme Court has remanded regarding the compliance orders back to the commission. But I anticipate when the commission when the Supreme Court receives notice that the commission of this order and SEC withdraws its appeals of the 2 compliance order and the 2 writs, I anticipate that oral argument would be scheduled in the appeal of the final order, and that ultimately there would be, I cannot say when, but ultimately there would be a final decision from the Supreme Court after oral argument. So that appeal will still go on, but everything else will get dismissed, or SEC will withdraw them. SEC is not waiving any argument. It may assert in connection with fines imposed or any argument it's made in connection with its appeal. SEC is not waiving its right to appeal the imposition of fines imposed by the commission following its suspension of the fines. In other words, if down the road the commission decides that it wants to continue to pursue fines, it's not waiving its right to appeal those fines in the future. However, existing fines from the initial 2020 compliance order will be suspended to be revisited upon ultimate resolution of the appeal by the New Mexico Supreme Court. All of the terms of this stipulation are subject to the commission's approval of the stipulation. Should the commission not approve the stipulation, none of the terms will be in effect. Regarding the rates, SEC agrees to immediately, no later than May 11th, 2022. And I've already said that they filed it on May 9th. File an advice notice with the commission containing the rates adopted in the final order. Those rates are set forth specifically in the hearing examiner's RD Exhibit 2. They're attached as Attachment A and made part of the stipulation. SEC agrees to continue charging the rates adopted in the final order no later than June 3rd, 2022. SEC bills on the 15th and final day of each month. Meaning that I read those two sentences together as meaning that when the bills go out on the 15th, they will have the new rates of the 15th of June. Finally, regarding the customer notice issue, Socorro Electric agrees to provide the customer notice that the commission originally directed them to issue in its compliance order in April 15th, 2022. And a copy of the notice was attached as attachment B. And it's this, I've checked it, and it is the same notice as we directed them to file. SEC will provide notice by publishing the notice in the July Enchantment magazine and by posting the customer notice in a prominent place on its website. For the reasons that I stated on May 4th, I believe that this stipulation contains the terms of the compromise. The compromise is beneficial to the commission because SEC has now complied with the final order and has issued the advice notice. Therefore, this proposed order would adopt the written stipulation subject to all the decretal paragraphs of the May 4th order and made contingent upon the following. Within 7 days of this order, SEC would have to file a withdrawal of its appeal of the April 15th, 2020 order. That's the first compliance, and would have to withdraw its appeal of the March 30th, 2022 revised compliance order and withdraw its motion to stay before the Supreme Court and withdraw its two petitions for writ. And I stand for questions.
Thank you, Judy. Any questions for Judy?
Mr. Chair.
Vice Chair Hall.
So Judy, I thought, I'm a little confused with your last sentence. I was thinking this is all fine, but we issue this order today, and then as you had stated, Socorro Electric is going to have to withdraw their appeals to the Supreme Court, except for their original appeal relating to the rates. Correct?
That's correct. And they agreed to do that in the stipulation.
Yeah.
So,
Okay. So was your, go ahead.
just giving a deadline, 7 days.
Oh, okay,
Actually do what they agreed to do.
great. That's fine. Okay, thanks. Thank you, Judy, and thank you, Mr. Chair. Mr. Chair, if there are no other comments in this case, I would make a motion to approve the order.
Okay, we have a motion on the floor to approve the order. Do I hear a second?
Second.
Second by Commissioner Fishman. Any discussion on the motion? I just want to commend staff for coming up with this stipulation. Again, as I said before, regarding this case that's been going on too long, that it's not a global kind of settlement, but I think it It addresses the heart of our original issues, which is the rates. And so I'm pleased with this going forward. Again, I hope to use more alternate dispute resolution techniques to, maybe minimize the possibility of protracted litigation, but it is what it is. But I want to commend staff and SEC for coming up with this agreement. Any other further discussion on this? We're adopting an order approving Socorro Electric Cooperatives and staff's stipulation without amendment. Any further discussion? All right, hearing none. Russell, roll call vote, please.
Mr. Chairman,
Aye.
Commissioner Hall,
Aye.
Commissioner Vicente Aguilar,
Aye.
Commissioner Fishman,
Aye.
and Commissioner Byrd.
Aye.
Mr. Chairman, the vote is unanimous to adopt the proposed order.
Oh my God, it's not even 10 o'clock and we're almost done. Could this be our first rocket docket? No. All right, I'm not going to jinx it. Let's continue. Let's move on to the next agenda item in docket 21-112-UT in the matter of the commission's adoption of rules pursuant to the Community Solar Act. And we will be discussing and taking action on a potential order regarding 9 pending motions for rehearing, potential order regarding Southwestern Public Service Company and El Paso Electric Company's motion for procedural clarification and for stay of implementation. Russell Fisk, you want to tee this up for us?
Yes, Mr. Chairman. So hopefully you have all received, commissioners, my email last night, which had I had not previously provided you with Exhibit A to the proposed order, which is the actual proposed changes, to the rule language itself that I sent last night. But you already had from Monday the proposed order itself. I did make one change as described in that email as a track change last night, but otherwise that was the same. So I just want to make sure everyone's referring to the correct documents. And I did not make any changes to the memo that I sent on Monday. So I'll be following that memo, which is very, very closely follows the order. So as described, today the commission will be addressing 9 motions for rehearing / reconsideration / clarification. Those are all descriptors that are used in the titles of these motions, but procedurally, the commission should treat all of them as motions for rehearing under the Public Utility Act, Section 62-10-16, under which section this is the last day or a last open meeting at which the commission can. Yes, Commissioner Vicente Aguilar. Can you not hear me?
Excuse my interruption. There's 9 parties that requested rehearing regarding the case and for the adoption of rules on community solar. Russell, can you give me your synopsis why this is happening?
Commissioner Vicente Aguilar, are you asking why there are so many commenters why there are so many of these motions?
Yes, I would like a legal advice why this is being countered by 9 parties. What's the huge process that we have overstepped or did not fulfill?
Commissioner Vicente Aguilar, my opinion, and I've described it in the memo, and it would actually be included as a commission finding in the order, is that the commission has done everything right procedurally. there are some allegations, false allegations or incorrect allegations made by the utilities that we have done something wrong, and I will address those. But most of the claims made in the motions are not that the commission has done something wrong, but that, basically these are commenters who are had different proposals, had proposals that the commission didn't adopt with regard to the rule. All of these motions concern the commission's order adopting rule, and thus the content of the rule that the commission adopted. And so a lot of these aren't saying that the commission did something wrong. Mostly they're saying, we really think you should have done what we asked in our comments. We thought that was a better option. And in some cases where I'm, the community solar action team is actually recommending changes, but mostly not. And so procedurally, I can get into that. Right, it's actually, right away in the memo, the allegations of any, failures, procedural failures by the commission with regard to the rulemaking. But my opinion is that the commission has done everything right, and I will describe that as I discuss those issues. Is it okay for me to just proceed then, Commissioner Vicente Aguilar? Because I will get to those issues right at the beginning, pretty much.
Yeah, Commissioner Vicente Aguilar, there'll be ample time for questions. If we can just maybe let Russell make his presentation, and then we can ask any questions.
Mr. Chairman?
Yes.
Yes, Russell can proceed with the presentation, but I asked my questions for the public. The public are listening to this meeting, and they don't see the memo, and I want them to understand the background of where our general counsel's office is directing, so that we can vote on this particular case. So thank you very much, Mr. Chairman.
Thank you, Commissioner. Please proceed, Russell.
Thank you, Mr. Chairman. And one thing I would add to what I just said is that perhaps one reason why there are so many motions is because community solar is a brand new rule, a brand new program, and there were so many different possible ways to approach so many different issues that it's sort of not surprising that we had a lot of comments, and then we have a lot of motions for rehearing because there are lots of options. But I will proceed onward. So there are, as I said, 9 motions for rehearing / reconsideration, which go to the content of the rule itself. There are also, there's also excuse me, a motion for procedural clarification, which is not subject to the motion for rehearing procedure. We're just considering it as a general motion. That was filed by SPS and EPE, in which they also asked for excuse me, a stay of implementation of the community solar program. When I refer to the program, that's how the Community Solar Act refers to the entire statewide program. In other words, everything that the commission and everyone involved in community solar will be doing statewide, that's all considered the program. So if you hear me say the program, I'm referring to everything, the whole shebang. So there are, as I said, I'll be getting to these discussions of these procedural objections that have been raised with regard to the commission's rulemaking. Okay, so what I've done in the order, the proposed order, and also in the memo, is I grouped the comments by utility comments. I'm sorry, not comments. I keep saying comments. Of course, this has been a rulemaking proceeding, so before there were comments. Now there are motions. The motions filed by PNM, EPE, excuse me, scratch my throat, and SPS, their motions for reconsideration / rehearing, and also SPS and EPE's motion for procedural clarification are grouped together for discussion because the things that are raised in the issues that are raised in the motion for procedural clarification, EPE and PNM and SBS all raise those in there, raise similar and some of the same issues in their motions as well. So all the utility motions are grouped together. That's 4 of them. And I'll discuss those first. And then all the, pardon me, all the non-utility motions are grouped together. Those are by commenters other than the utilities who filed motions for rehearing, because generally there's some alignment among the utilities versus the other commenters. There's differences among the comments by the other commenters, but it's helpful to group them together. So I'll begin with the the utilities motions, those 4 motions that I just discussed.
Russell?
Yeah.
Russell, excuse me. When you get to the part of your presentation where we accept, some of the recommendations in the form of changes to the final rule, I don't know if it's better for you to maybe display Exhibit A, which is the final rule with track changes that represent the recommendations that we're accepting. How would you like to proceed? Because I do want to display the rule with the track changes. So when you get to that certain point, you can determine whether you want to display the rule or go through your presentation first, and then we can go back to the rule and just revisit all the changes in response to some of the recommendations that we're accepting.
Mr. Chair?
Mr. Chairman, that's a good idea, and I would do that right now, actually.
Hold on, Russell. Commissioner Fishman?
Yeah, I was just going to suggest, at least for me, putting up the rule would be kind of the most clear way to be tracking this.
Yes, I can do that. Or Isaac, I don't know, or whoever. Isaac, should I do that, or do you want to do that?
I can throw it up if that's easier for you, but you are also able to share your screen if you prefer to be in charge of
Okay,
sharing.
let me do that then. I will share my screen so that I can move through the rule. Let's see here. All right. Okay, I think that's a very good idea. And if you're following along, excuse me, in the memo, I'm actually skipping past the summary of the motions because I'm skipping right to the team's recommendations with regard to the motions, because otherwise this would be a very repetitive discussion. Because as I discuss the team's recommendations, I will, fill in the commission on what the motions were, and what we're addressing there. So I think it's better to just go right to the team recommendations in the memo, which start on page 4. So, so first of all, you won't. Now I'm still sharing the rule, right? I just want to make sure that you're seeing the rule. Is that correct?
Yes.
Okay. Well, first of all, the first thing that the order will address and that the memo addresses here doesn't pertain to the actual content of the rule. You don't have to refer to the rule for this. Is about the procedural objections that have been raised, really by all the utilities, but especially in the procedural motion for procedural clarification. And the procedural clarification focuses particularly on the commission's use of the Community Solar Action Team, which is referred to as the team, in this proceeding. This is in the order. The proposed order would describe this particular the motion and these, as I refer to them, suddenly urgent concerns regarding the team to be, disingenuous. This really appears to be part of a building of a record for appeal. There are certain issues in this matter, particularly the issue of transmission costs, the inclusion of transmission costs in the solar bill credit or the removal of of such costs, or the reduction of the credit, that we have been, all along, as I've advised the commission, expecting to get an appeal on. And I believe at this point, what we have from the utilities is in these motions, a sort of kitchen sink approach to objections, raising a lot of objections that, or at least some objections I think are disingenuous. And this is one of them. There are also objections and proposals that are raised that are reasonable, or even so meritorious that I'm recommending, that the team is recommending adopting them. But this one is a bit honestly hard to take. The commission has used a team from the very beginning, a dedicated team from the very beginning of this process, with no objection from the utilities or any of the parties. In the commission's initial order, the commission stated that the team will take a leading role in the rulemaking process. We'll interface with Stratagen. That was the commission's contractor for the stakeholder outreach and stakeholder process, which is generally the informal workshop process and the reaching out to all the potential stakeholders, which was something that is actually specifically required by the Act, that kind of stakeholder interface. And so, so it stated from the beginning that the team would take a leading role in this rulemaking, would interface with that contractor and maximize stakeholder engagement. Nearly every commission order that's been issued in this proceeding has included specific recommendations from the team to the commission. The team has specialized in this area. And of course, one member of the team is Art O'Donnell, who is our very, very helpful consultant and Department of Energy fellow in this matter. We've developed in the team a focus and expertise on this area of community solar, which is completely new to the commission. It's an area which the commission has no experience. And so having having a team, which included 2 commissioners, specifically focus on this and provide, and building an understanding of what community solar is, who the players are, how it works, what the issues are, was extremely helpful in this proceeding. And the order would say that, especially because the commission has so many other newly delegated areas of responsibility that have been delegated by the legislature, that it makes sense to use a team approach where there are people dedicated within the agency to particular areas. And so, members of the team this team can focus on this. Members of other teams for other rulemakings can focus on other issues. We have a lot of things to learn. Essentially, we have so many new areas in which we're to be rulemaking. So it makes all those points, and that's why it notes that the order would note. I'm sorry, must be the smoke. Would note that this is an untimely objection, because the team has been referenced since the beginning of this case. No objections were made, and it's meritless. The one clarification that I do feel, was reasonable to ask for, was a clarification as to the participation of, there were 2 members of the team who were also members of staff. And so it was reasonable for the utilities to ask, well, gee, those members of staff, they weren't involved in discussions after the closing of the record, were they? And this would confirm that they were not, because that would be an ex parte communication. Staff was a commenter in the rulemaking. They filed, written comments, and this the order would confirm that the only comments, the only input from staff that was considered by the commission in this matter was the actual written comments when it came to the formal part of the rulemaking after the NOPR was issued. So everybody who was involved as a commenter could see exactly what staff was recommending, and the fact that there had been 2 staff members on the team, well, they weren't involved after the record closed, so there were no ex parte concerns. that was a reasonable clarification to ask for. Otherwise, I feel these procedural objections were really at one point were really just to prepare for an appeal and to use more ammunition in appeal. And I really do believe they're disingenuous. So the order would say that. The other procedural issue that's raised is the utilities are claiming that all all efforts at implementation and of the program must be done through the rulemaking. And in other words, be part of the rule. And that is also, I think, a disingenuous argument, because the implementation of the rule or of the act of the commission's duties under the act, the implementation, excuse me, of the program involves rulemaking, and it also involves things that are could not possibly be considered rulemaking functions, such as the commission knows, the team has already sought contractors. A contractor has already issued, the commission has issued an RFP process pursuant to the team's recommendation and has received responses for the selection of a program administrator. And the rule provides for a program administrator, a third-party program administrator. The rule identifies that we're going to use one, the commission will use one, but the efforts to select the program administrator absolutely do not need to be part of a rulemaking. They're clearly part of implementation, a part of the implementation of the program that is a contracting function that, you know, the commission will follow the Procurement Act and its usual procedures for contracting. It's absurd to claim, the utilities actually claim every part of every implementation effort should be included in the rulemaking, which is, that's a disingenuous argument in my opinion. So we have included in the rule, the commission has included in the rule, has addressed every issue it needs to, has set all the policy that it needs to, and from that can flow actions that are not rulemaking, such as contracting and providing instructions to contractors, things that will be part of the ongoing administration of the program as well. The order would note, this is a very different sort of statute than the commission usually administers. Because with most of the statutes that are administered by the commission, the only ongoing administration duties of the commission are adjudication and rulemaking. Here, there will be adjudication and rulemaking, but the commission will also be managing, well, through an administrator, but probably also through some commission actions, the program, an ongoing program in which applications are received, selected via criteria that are provided in the rule, and issues we raise. Some will be for adjudication, others will be to manage the process and use our contractors in the best manner to promote the goals of the program. So there are going to be plenty of things that have to be done pursuant to the rule, but that don't require rulemaking. So
Mr. Chair?
Yes, Commissioner Fishman.
Yeah, Russell, pardon the brief interruption here. I assume that utilities would like to have a voice in choosing the administrator. Can you give some examples where the commission uses administrators, where the impacted utilities do not have a voice in choosing that contractor?
Well, absolutely, Commissioner Fishman, that's a very good point. One area in which the commission has ongoing administration duties that go beyond rulemaking and adjudication and actually manages money would of course be the State Rural Universal Service Fund. The commission just recently, just this year, or maybe it was this year, I believe, renewed the contract with for the fund administrator with Vantage Point Solutions, and that's chosen through an RFP process in which none of the stakeholders, the people who receive money from the fund, they're not part of that process. It's done pursuant to criteria that have been established by the commission, and it's for the purpose of finding someone who will most effectively, efficiently, and cheaply administer the program. Same thing, same thing here. An administrator will be carrying out duties, but the administrator is not going to have a great deal of discretion because the rule has a very specific set of minimum eligibility criteria for considering proposed projects, and also a very detailed set of criteria for awarding points, including the number of points to be awarded for very specific attributes of a proposed project. So
Okay, thank you. That's all I needed to hear. I just wanted to make it super clear that what's being proposed here is nothing new or no big stretch from what the commission has done for a long time.
Absolutely, yes, I would concur. And I'll get past this subject and move on. I just wanted to note that the commission actually, by single signature order, opened a docket separate from this rulemaking in February of this year. And it said explicitly in that order that the new docket, which is 22-00020-UT, the implementation docket, would be for implementation and administration of the program, would be for those efforts of implementation administration that are not rulemaking efforts. In other words, there are some implementation provisions that are provided that are done in the rule. They're in the rulemaking that were part of the record in the rulemaking and are decided in the rule. And there are other efforts that will not be. I mean, that was expressly stated. There will be efforts that we make for implementation and administration that will not be in the form of a rulemaking. And that was in February this year. No objection at that time. So I feel like this is a last minute, let's build a record for appeal sort of approach. Let's see. And then the order would also note the commission has a sense of urgency in implementation of the program because the utilities argued that, excuse me, that since that we were still in the motion for reconsideration period, that there shouldn't be any, pardon me, I'm sorry for my voice, that there shouldn't be any non-rulemaking efforts at implementation, such as a couple of weeks ago, staff held a workshop for providing more instruction and guidance as to how to draft tariffs that are due under the rule from the utilities within 60 days of the effective date of the rule. That then these tariffs would be to specifically show the breakdown and the calculation of the solar bill credit rate that would be applied to arrive at the credit for each subscriber to a community solar facility. And what the order would say is that the utilities actually were reasonable and cooperative in their behavior with regard to that workshop. They participated in the workshop while filing a notice that they were reserving their rights to challenge one of the major aspects of the solar bill credit rate, which is whether transmission costs should be allocated, whether any portion of transmission costs should be allocated through the credit to subscribers. That was, precisely how they should proceed. They were cooperative, with an understanding that implementation of the program needs to get going. Essentially, that there's an urgency in the act itself to start the program, and they properly reserve their rights. And so the order would say it's surprising that a few days later, just I think 2 days later, the SPS and EPE filed a motion for procedural clarification in which they described this situation basically as untenable. We can't go forward with implementation efforts during this period when they had already very reasonably handled it. So that also to me seems very much like, oh, let's build a record for the appeal. Let's pile on every objection we can imagine. So this order would address those arguments, but would note that they are seemingly disingenuous. So I'll move on from that. Let's see. So the team recommends that the commission deny the request for a stay of implementation of the order adopting rule. That's actually how it's phrased in the procedural clarification motion as groundless and dilatory, for the purpose of delay. And the team recommends that the commission refrain from reopening the record. That's something that P&M asked for in its motion for rehearing. We've had 3 rounds of comments and a public hearing before. That's in the formal rulemaking process pursuant to the State Rules Act. But before that, there's a very long workshop process. So there is no more record that is needed. There's a very extensive record. So I'll move on now to the motion, the utilities motions for rehearing with regard to the substance of the rule. And what I'm going to do is address the proposals that the team as expressly made recommendations to the commission about whether to adopt or not to adopt in the order. The order itself says not every not every proposal or every argument is addressed in the order adopting rule because one, the commission does not have to for motions for rehearing, does not have a duty to address all arguments because motions for rehearing may simply be denied by inaction of the commission. The commission does not have to consider them at all because it's reconsideration and many essentially usually the issues that are raised in motions for reconsideration have already been raised in comments but the team does address, has made recommendations with regard to many proposals, and I will go through those. And then at the end, I'm going to let the commission know which proposals aren't even addressed in the order because they're ones that have been soundly rejected by the commission, and we don't believe need to be even addressed. So getting to the substantive issues raised by the utilities. P&M had objected to portions of the rule concerning interconnection cost sharing and cost recovery, as well as recovery of administrative costs associated with the community solar program. That would be the utilities' own administrative costs. The utilities will not be the administrators of the program, though some had asked to be. We'll have our own program administrator, but they will incur presumably some costs. Perhaps they may have to hire someone who specializes in community solar. I'm not sure if that's what they plan to do. They don't describe what the costs will be, but surely they will have increased costs separate from the costs of interconnecting community solar facilities that could be called administrative costs because they're going to have to process the solar bill credit through bills. So that's certainly an additional billing duty. And the team agrees with P&M that the act requires that there be like a mechanism that it allows for recovery of those costs only from subscribing from the subscriber organizations. In other words, the community solar participants and their own subscribers, and not from any non-subscribing ratepayers. So there should be a special mechanism to make sure that no non-subscribing ratepayer is subsidizing this administrative costs or interconnection costs. So for administrative costs, the rule would add, and I'll go to the rule language because we're talking about the rules. So you have the rule in front of you. Is that correct? Can you see the rule? Mr.
Yes.
Chairman? Okay, let me get into here. Sorry. Trying to maximize this so I can see what you see. So I'm just trying to get my view of the screen to show everything. Some of the things I find most
Russell, are
challenging.
you sharing your screen or is that Isaac?
I am sharing it for the rule. Just trying to get a full screen here so I can see this. Oh, I see. Okay.
Yeah, if you can start going to the sections that represent the recommendations that we're accepting.
Yes. I'm just trying to see the rule myself here. sorry, I have an odd view that's come up with regard. Isaac, how do I get a full screen view of my Zoom? All I have is this partial, this minimized, somewhat not totally minimized view, but I can't see the rule that I can't scroll through it as
You
I
may
just have
want
this.
to try stopping the share and then starting it again.
Okay, thank you.
Yeah.
Thank you. Okay, now I've got it. Thank you. So I'll do this again. All right.
Hey, we're not seeing it yet, Russell. There we go.
You see it now? Okay. So thank you, Isaac. So with regard to this mechanism for recovery of administrative costs from only subscribing ratepayers and subscriber organizations, in other words, participants. Let me go to the, here. It will be, I've included a redlined proposed change to subpart 13, which would also change the title. This section subpart was dedicated to interconnection cost sharing. Now it'll include interconnection cost sharing issues, but also I will discuss administrative costs. So I go to D, is what D adds this. A utility may recover administrative costs of carrying out its responsibilities concerning the community solar program through a rate rider from which non-subscribing ratepayers are exempt. A utility may apply to the commission to establish such a rider. This answers the two things that the utilities were concerned about. That one, they'd have to wait until a rate case to recover these costs. And they said, during that period, there'd essentially be a sort of the ratepayers as a whole would be carrying that cost. And so this rate rider is the quickest way to get approval of something that can be implemented right away for such costs. And it would expressly not apply to non-subscribing ratepayers. So there'd be no subsidization of such administrative costs by the non-subscribing ratepayers. So moving on then to the interconnection cost issues. The utilities asked for a mechanism in the rule for them to recover interconnection costs. That is, the costs that arise when a community solar project for the developer or the subscriber organization actually applies to the utility for interconnection. There's a costly interconnection study, and there's then the actual costs of interconnection, which may require certain upgrades to the grid. It's unclear why the utilities are asking for any kind of special mechanism here, because the utilities already for any kind of interconnection bill the person who's requesting interconnection, which makes sense. That'd be the subscriber organization. That's proper. That that billing is done under the interconnection rule, which, as you know, is currently in a rulemaking. But the existing rule and the whatever amendments are adopted will, of course, include provisions for this practice to carry on. It's not even in question. So the team does not recommend any special mechanism for community solar. It can simply be billed as the utilities always do. Now the difference here is something there's something already in the rule where about interconnection cost saving in this very section, the commission has already approved, which is that the commission will consider, let me just scroll up a little, on a case, so I'm looking at A, the commission may determine on a case-by-case basis whether the cost of distribution system upgrades necessary to interconnect a facility may be eligible for some form of cost sharing. So when the utility bills an applicant, I think in many cases, the applicant will simply pay the bill if they're able and go ahead with the interconnection with their own subscribers bearing the costs, all of the costs. But the commission does provide for a procedure in which, having received a bill possibly for tens of thousands of dollars in upgrades or more, or even more, that the applicant, the subscriber organization, can come to the commission on a petition and say, some portion of these costs will benefit non-subscribing ratepayers, and that it would not be a subsidy for those non-subscribing ratepayers to pay their fair share of the costs that will provide benefits to them. So again, it'll begin with the same procedure that the utility already uses, which is if you want to interconnect, you're going to pay the cost of the study and you'll be billed for the costs of the application. But then an applicant can come to the commission and say, and petition for cost sharing. And I've provided some more specificity in section C because there had been an error excuse me, in the rule that the utilities pointed out, which is that we had referenced in this section about interconnection costs, the Community Solar Act's allowance for cross subsidization by non-subscribing ratepayers of certain costs, associated with community solar, up to 3%. But the utilities properly pointed out that 3% allowance, in other words, an allowance that would actually allow for actual cross subsidization of the program to some extent by non-subscribing ratepayers, doesn't apply to these types of costs. It doesn't. It only applies to the community solar bill credit. In that credit, the commission may allow up to 3% of cross subsidization on finding of that's in, I believe, the public interest. But what this revision would do in the red lines is remove this reference to the cross subsidization up to 3%, because that does not apply here. They're correct. And so what's clarified here is that if on a petition from an applicant for interconnection to share some of the costs with other ratepayers, the commission will consider approving such interconnection costs or sharing of such costs with non-subscribing ratepayers only to the extent that the costs borne by such ratepayers are matched or exceeded by demonstrable benefits to such ratepayers, so that there will be no subsidization of interconnection costs by non-subscribing ratepayers. None at all. It'll only be upon a finding that there is a net benefit, or that the costs are outweighed by the benefit, the costs that would be charged to non-subscribing ratepayers. The commission could properly consider that to be no subsidization at all. So anyhow, I'll take any questions if there are any questions on this area.
Mr. Chair?
Commissioner Fishman.
Russell, quick question. We've had other cases come before us where we talk about cost causation, and the party creating the cost is responsible for paying the bill. And this gets a little bit more nuanced, it seems to me, than what we've done in other cases, in that it identifies that a portion of the cost may be borne by others, but you still primarily, go back to the cost causation, and the party that originated the cost probably takes on the lion's share of it before you divvy it up. Am I interpreting that correctly? And does this in any way impact those other cost causation issues that we've raised in other dockets?
Commissioner Fishman, I think it does. It does. Certainly, this is an issue of cost allocation, and cost allocation is generally done by cost causation, by reference to who is causing these costs. Now, so this is very much related to such other cases. The term that I think I've used in the order is, costs that have been occasioned. In other words, that the question of the cost has arisen as a result of an interconnection request. The costs are caused, yes, by the interconnection, except I think it's reasonable for the commission to say, to the extent that these costs would have been incurred later, in the absence of the facility being interconnected, such as things that upgrades to the system that would could reasonably be anticipated to be needed in the near future, and other things that the other utility ratepayers would have had to bear anyway, then those are costs I think the commission could find not all of these costs are really caused by this facility, because by interconnection of this facility, because some of those would have been incurred anyway, or some of them will some of this the upgrades will have a benefit to the grid such that other costs would be avoided in the future. I think it's a difficult showing. I think it will be a difficult showing, and that, you know, the commission should apply the cost allocation standards it has before. And this is this I think will be a difficult test for petitioners to show, as it should be, but it allows for the possibility. And I think I formulated this language, but it's we've been discussing on the team. I made it more explicit here because I felt since we're recognizing here that no cross subsidization is allowed, not even up to 3% for this type of cost, that I went ahead and I sort of formulated what I think the team has been discussing as a test, which is about as stringent a test that you can have without actually just saying no, all costs shall simply be paid as per, as they're occasioned by the connection of the facility.
So Russell,
that help?
this language appeals to my sense of fairness. So I like it. I just want to be sure that it doesn't throw any other cost causation stuff that we do into a state of confusion. What you seem to be telling me is no, because it's a fairly high bar.
Yes, and without actually referring to any particular cost allocation principles which may apply in certain situations, I'm just going to say cost allocation, as the commission knows, is one of the most difficult areas that the commission ever has to address, because it often involves consideration of hypothetical situations. And you, sorry, excuse me. You should have described that, a demonstrable benefit that an applicant might show is that, eventually, yes, my interconnection will cause these costs to rise because these upgrades will be needed now. But those upgrades would have been needed in a few years anyway for these reasons. And so it's unfair to make only the subscribers pay. These involve, future projections and hypothetical situations, and those are addressed in other cost allocation cases. But it's a very difficult. It's always one of the most difficult analyses that has to be done, because it does involve considering, well, if we didn't interconnect, or if such and such situation, if someone wasn't applying for this particular had this particular application, would these costs arise anyway? And that's it's difficult. But I think that's would be considered here. That would be considered, as it has been considered in other cost allocation cases.
Thank you.
Yes.
Thank you. That covers the point for me.
Okay.
Thanks,
Quite well.
Commissioner Fishman.
All right, so let me move on. And most of these issues will not require this long a discussion, but this was a complicated and important issue. So let's see where we are now. Let me get back to my memo. So if you're following along the memo, I've been on page 6. We've gone past interconnection costs and administrative costs. And again, I'm noting here, this is the commission here. The team is recommending adoption of the utilities recommendations, or at least some of them. So not all of their arguments are disingenuous. Some of them are substantive, and we've addressed them. Let's see. Where am I now? Okay. The next issue I'm going to address is co-location. Co-location, the Act prohibits co-location of community solar facilities, but it doesn't define what co-location is. And as we described when we were the team, Art and I, particularly when we were discussing this matter before the commission, when the order adopting rule was considered by the commission. We didn't have an understanding of what a co-location issue was. We didn't have a clear understanding of what that was getting at, and the act wasn't telling us. So we made an interpretation that the concern that was motivating the legislature to prohibit co-location was a concern that the grid might be overburdened at any particular location, by connection of multiple facilities. So the commission adopted, pursuant to the team's recommendation, a safe harbor provision that stated, as long as two community solar, as long as only one community solar facility is attached to any particular substation, then it will not be considered co-located, and that any other situations will determine on a case-by-case basis. We were wrong, and I don't have Art available today, unfortunately, but Art agreed with what the utilities and also some other commenters said about this matter, particularly REIA, one of the non-utility commenters said, that's not what, pardon me, sorry, that's not what co-location is about at all. Co-location is actually aimed at preventing gaming of the system by subscriber organizations, by developers who are doing the facility, who are creating the facilities. And the gaming would be this. It's a little bit similar to like lot sharing in the world of transportation, motor carriers, which is that, as you know, the Act and our rule prohibits any community solar facility with a capacity over 5 megawatts. 5 megawatts is the maximum. And the gaming that might be done, and apparently has been done in other states occasionally by developers, is that the developer will subdivide a parcel to allow for the possibility of more, essentially a facility that's composed of separate facilities that are very closely located, but they're on separate subdivided parcels, so that they actually total more than 5 megawatts. In other words, to get around the 5 megawatt limit. So the team would, and I'll go back to the rule here. Let's see. The team recommends fixing that to actually address what co-location is truly about. So I'm going to go down to the co-location provision. Here it is. Okay. So co-location, and this revision is adopts word for word the proposed language by, I believe it was the set of joint commenters, which included a number of non-utility commenters, but it's also in accord with what the utility said in their own motions. That instead of, it wouldn't refer to substations, it would refer to parcels. And again, it would be a safe harbor provision. It would say, as long as a community solar facility is not located on the same parcel as another facility, it shall not be considered co-located. And then it would go on to say, for any parcel that has been subdivided in the 2 years prior to a community solar project bid, all subdivided parcels should be considered a single parcel for the purposes of this rule. So that's going precisely to this gaming of the system, which would even apply to developers who were a gaming, a sort of scheming developer who was very forward-looking, who did the subdivision within the past 2 years in an effort to avoid the 5 megawatt limit. So I can take any questions on this if any commissioner has.
Any questions for Russell so far? Any questions?
So,
Commissioner Fishman.
Yeah. So Russell, this last sentence that could potentially case by case allow more than one facility on a parcel, is that specifically aimed at very large parcels where they could be on the same parcel, but they would still be geographically pretty far apart? Is that the situation you're looking at there?
Yes, there could apparently, parcels can be extremely large, and in some areas of this state might be enormous. And that's also in accordance with the joint commenters. This is part of their recommended language. In other words,
Okay.
they recognize there are, they're the ones who they're pointing out very clearly what the gaming might be, but they're also acknowledging there could be reasonable situations in which that's done. And I think a very large parcel would be that situation.
Okay. That's very straightforward. Thank you.
Okay, well, I'll
Any
move
other
on.
questions so far? Any other questions for Russell? All right, proceed, Russell.
All right, so, okay, so if you're following in the memo, excuse me, I'm at the bottom of page 6. The team recommends that the commission reject, pardon me, a proposal by P&M to provide special definitions for terms used in the uniform disclosure form. As you will recall, that's a form that the commission was required to adopt with the commission providing the actual content for the form by the act. That's one of the subscriber protection provisions that the commission was specifically required to do under the act, which is a form that subscriber organizations would provide to potential subscribers that would disclose certain things, such as the amounts and types of any rate discounts, the other provisions. I don't have the form in front of me. The utilities asked for special definitions in the rule for basically all of the terms, all of the things that have to be disclosed. And the team does not recommend special definitions because the terms that are used in the form, I can get the form. Well, actually, I could go to the rule because it's described in the rule. Let me go to the rule. Just quickly, try to be quick about this. Oops. Sorry, I just have so many things open. Sometimes I'm actually going to stop the share and start again to get to the point of the rule that I need to be. Okay, so now you can see the rule now, correct, commissioners? Mr. Chairman, you can see the rule. Okay, sorry about that. So in subpart 16, subscriber protections, it notes the commission has adopted a uniform disclosure form. That was actually attached to the order adopting rule, identifying what information has to be provided by organizations to potential subscribers. And this, the key contract terms are subscription size, estimated, I'm not going to list all of them, but estimated contract effective date, contract term, all of these. The team does not recommend that special definitions be adopted for any of these. These are all terms that can be interpreted reasonably by the organizations and the subscribers based on common understandings of these terms. This is an argument I'm going to say that appears somewhat disingenuous. Why these would have to be specially defined is beyond me. So we don't recommend special definitions. Also, one of the particular terms that was raised as one needing a special definition was rate discount, which is one of the terms. And the utilities argued that, and this may be only P&M. When I say the utilities, they made many of the same arguments, but there are some that were only made by one or two. But I'll just say the utilities. The utility said, well, pardon me, subscriber organizations may have different ideas of what rate discount means. And what the team would say, what the order would say, proposed order is, well, the subscriber organizations may actually have differing types of rate discounts. And the commission is taking an approach to regulating subscriber organizations that allows for such differences. And if the commission adopted the special definition, it might it would limit that. So this is consistent with the commission's approach to a lighter touch sort of regulation of subscriber organizations. So that's the recommendation, is to is to reject that proposal by the utilities. Okay, moving on. Okay, so the next issue is another one that the commission or the team does not recommends that be rejected. This is a proposal by P&M to provide a special definition of the term addressable market. This is a term, and I'll go right to the rule again. Okay, this is a term that's used in the subpart of the rule that apply subpart 11. Did you have that in front of you? I just want to make sure this is working, Mr. Chairman.
Yes, yes,
Okay.
we can see it.
Okay, the statewide capacity program caps. The act requires the commission to adopt a statewide initial cap of 200 megawatts for the capacity of the entire community solar program. It's something that we will revisit in a couple of years through a rulemaking to determine the size of the permanent cap. But at this point, it's 200 megawatts, and it was to be allocated by the commission among the three qualifying utilities, which are the three IOUs. And our rule uses the language addressable market estimations, which is something that was proposed by the utilities. And these, as Art described to me, this was proposed by all three utilities in a workshop, which as a methodology for allocation of this capacity cap, based very reasonably on the number of customers served by the utilities. The utilities that serve more customers the utility that serves more customers will proportionally have a greater amount of the cap allocated to it. And then the allocations are done in the rule. So the team does not recommend a special definition, as the utilities, which are understand, they proposed this way of proceeding. Plus, the rule gives the allocations. So these are the allocations: 1, 2, 3 under A. And even if there was some misunderstanding as to how we had arrived at them, which there isn't, the allocations are there. So this is, I'm going to have to say again, bordering on disingenuous, if not absolutely disingenuous argument. I mean, to ask for a special definition of something that really only the utilities need to understand, for functional purposes, and something that they actually recommended themselves. It's a bit much, I'll say. Going back to let me see what's next on. I think we're actually through. Okay, the next issue though, is interconnection standards. All three of the utilities argue that the commission is failing in its duties under the Community Solar Act by not adopting within this rulemaking interconnection standards for community solar. And they point to a provision in the act that requires the commission, that's my language in front of me, that requires the commission, I'm quoting the act, adopt rules that, quote, establish reasonable, uniform, efficient, and non-discriminatory standards, fees, and processes for the interconnection of community solar facilities that are consistent with the commission's existing interconnection rules and interconnection manual. The utilities say that because there's a pending rulemaking in another docket for interconnection standards, that this rule and the community solar rule fails to comply with the act. The team does not agree. And the order would say, let me see here. I just want to get the right part here. That what is a better way, for one thing, of ensuring that The interconnection standards that are applied for community solar projects to interconnect are non-discriminatory, uniform, and consistent with the existing interconnection rule and manual, then to take care of them in that docket where the interconnection manual and the interconnection rules for all projects, for all interconnection of facilities that are under 10 megawatts, which could include, qualifying facilities under PURPA. I don't even know what else, that if they'd be consistent, then address them there. There really shouldn't be, and I'm quoting Art right now, much of any difference between interconnection standards for community solar and any other type of facility of the same size or approximately the same size. And it makes sense to do it there. To the extent that is still pending, well, it's consistent with the act that if there are interconnection applications for community solar facilities that are done before the interconnection rule is amended, they'll be processed pursuant to the existing interconnection rule and interconnection manual, unamended, the ones that exist now. And that's in conformance with the act. However, it's very unlikely that at the time that interconnection applications for community solar are actually submitted to the utilities, that there will not be such an let me state this in a clearer way. At the time that interconnection applications for community solar projects will be filed in the future, it is very, very probable that the interconnection rules amendments will be complete, that the interconnection rulemaking will be complete. And this is why. The utility has asked for confirmation. The utilities have asked for confirmation of three procedural standards that will apply to community solar. And one of them that would be confirmed and that would be added to the rule. And I'll get to the rule in a second, but I just want to talk about this conceptually, is that that the utilities need only consider interconnection applications for community solar projects that have been selected, that the projects themselves have been selected through the commission's selection process for the projects. In other words, interconnection applications will be filed after the selection process by the program administrator for projects, and the utilities need only consider those applications. In other words, they do not need to consider, the utilities do not need to consider existing interconnection applications that have already been filed that are in the queue for consideration for projects that have not been selected. And are eventually not selected. Interconnection applications that they consider will come after the selection process, the selection process, will remove a lot of projects from consideration. So there will be fewer applications to be considered by the utilities, and that will also manage the timing of this, because the selection process, I asked Art, when will that process be complete? As a projected time, and he said mid to late summer. I was discussing this matter yesterday with some members of the team. It could possibly be later than that. As we've not yet selected a project administrator. We've just received the responses to that request for proposals, so we don't even have an administrator in place. Plus, Art has said that he expects hundreds of applications. I believe he said 900 at one point is a possibility for project selection. And there's as the commission knows in the rule, there's a very detailed set of criteria, some of which may require some interpretation when we get the applications. So I don't know how long it'll take an administrator to go through hundreds of applications, but I'm guessing it's going to take a number of months. So by that time, we should have the interconnection amendments in place so that when it's time to file applications, which presumably for interconnection, which presumably the developers / subscriber organizations, they'll probably file their interconnection applications immediately after being selected right away. There will almost certainly be a rule amended standards in place. So I know there was a long discussion, but there were a lot of issues there.
Mr. Chair?
Commissioner Fishman.
Yeah, thank you. So Russell, I just want to kind of give my quick summary of all you've said. Essentially, the legislation says the rule needs to, at some level, or we need a rule, not necessarily this rule, to address interconnection. And what we've essentially done here is procedurally, in terms of the interconnection queue, this rule addresses that, but it leaves all technical interconnection issues to the separate interconnection rule.
Yes.
Is that a good summary?
Yes, very much so. And you're very, sorry, go ahead.
And the second thing I would say is, I think that is really wise, because if you have technical specs for interconnection, both in this rule and in the interconnection rule, that creates potential confusion. And it very likely isn't necessary, because there are no special technical requirements that for these types of projects.
Correct. Absolutely. Yes.
Okay. So I just wanted to put a clear summary on that I think the team has done a great job in addressing this and in making these practical distinctions.
Yes, and you're absolutely right. There's no failure to comply with the act by the fact that there are no interconnection standards for specific to community solar adopted in this rule, because the act is telling the commission, be sure the standards are consistent with your interconnection manual and your interconnection rule. Well, we're saying that rule and that manual will simply apply. And at this point, it would be the unamended rule. But as a practical matter, there will be no interconnection applications under the existing rule, because they won't be they won't be filed until projects have been selected, and then we will have an amended rule. So it takes care of itself pretty much. So I'm looking now at the rule, because this is getting to the next point. In the section 12 about selection of community solar facilities, this is a very involved section of the rule that actually talks about the requirements for projects to be selected, the criteria for weighting the projects, and then also discusses other parts of the process, the order in which things are done in the process, and the application fees, et cetera. So what the team would recommend adding to that subpart is this subpart I, which would provide 3 confirmations that the utility specifically asked for. PNM specifically asked for these, and they're all reasonable, and the team recommends them. I discussed them with Art last week. The first is what I just said. A utility must consider interconnection applications for community solar projects that have been selected by the administrator, as well as any projects from the wait list that replace such projects. There's a wait list provided here where because selected projects may drop out during the interconnection application process, or for that reason or for some other reason. There's a wait list ready for the projects that are ranked immediately below to step in. So a utility must consider any interconnection applications for such projects, and need not consider interconnection applications for projects that have not been selected or have not replaced selected projects. So that's clear already. The second affirmation is included right after. Among the group of interconnection applications for community solar projects that have been selected by the administrator, or have replaced selected projects. A utility must prioritize consideration of applications in the order of ranking by points awarded to each project in the selection process. That was something that the utilities actually asked for. And this is because, as I said, the administrator will do the selection process, then announce the group of selected projects and the wait list, and the points and the ranking. And then those projects will presumably flood the utility with interconnection applications, probably within a matter of days, I'm guessing, with a lot of applications. And so they want to know how to prioritize those within that group. And ranking by points awarded, the highest ranked projects, of course, do those first. This just seems reasonable. And then they also asked, the utility asked for confirmation, or PNM asked for confirmation that when looking at community solar project, interconnection applications for community solar versus other types of interconnection applications, for instance, one for a qualifying facility under PURPA, that's the only other example I have in mind. There will be no preference for interconnection applications for community solar projects, as opposed, I have a typo here, sorry, as opposed to such other types of interconnection applications, and vice versa. They'll, all community solar project interconnection applications will be on the same level playing field in terms of prioritization of, when the application is considered with any other type. And I'll take any questions on that.
Any questions for Russell so far? All right, we're almost there.
Almost there. So we passed, let's see, I'm just in my memo. Okay, so I'm on page 7 at the bottom of the memo. That was the last issue that the team recommends be addressed specifically in the order. And the team recommends that all other requests in the utilities motions be denied. And I will, I'll go through, I'd like to move on to what the order addresses. And then at the end, I'm going to give the commission a list of what is not addressed here. In other words, that's denied by silence.
So Russ, Mr. Chair.
Fishman,
Yes, Russell, were you going to cover the self-certification issue for low income?
Yes, Commissioner Fishman, that is actually addressed, will be addressed right now, because I would move on to the motions for rehearing by non-utility commenters. And that's one that's made there. So, okay, so I will move on then from the utilities motions to the non-utility motions. These are motions filed by the City of Las Cruces, REIA, Renewable Energy Industries Association, the joint commenters, which includes a lot of organizations of developers and other people interested in promoting community solar. I think Cypress Creek, which I believe is a developer of subscriber of facilities, Power Market, I don't remember the names, and US Solar. So these are all commenters who are generally, participants in community solar programs in other states, and represent developers and other people interested in expanding it. And then, of course, the City of Las Cruces, which is often a commenter in our commission matters. Okay, so first, there's a discussion. I'm going to actually skip again to just the points that are, so if you're in the memo, I'm skipping down to page 10 to the team's recommendations, which address most of what's described above in any event. Okay, so the joint commenters. First, they're addressing the joint commenters motion for rehearing, and the team actually recommends the commission adopt quite a number of the recommendations made by the joint commenters. And the first, as Commissioner Fishman referred to, is a self-certification option for low-income customers. This is something that the commission did consider in the comments and didn't provide in the rule. And I don't know, Commissioner Maestas, if you would like to address this. I know Commissioner Fishman would also like to address this issue. I can go to the rule and show you the language, but conceptually, this would allow for a low income ratepayer of the utility to be considered a low income subscriber for the purposes of the 30% subscriber goal, or actually requirement, that every facility has to meet, which is that at least 30% of the subscribers to the facilities, or 30% of the capacity of the facility is subscribed to by a low income subscriber. I can go to the portion of the rule, but I don't know, Commissioner Maestas or Commissioner Fishman, you would like to discuss the concept generally.
Yeah, please go to that portion of the rule, Russell.
Here we go. So under special subscriber provisions, first we had already in the rule under a set of eligibility criteria. In other words, pointing to other programs. If you're if a low income customer is enrolled in one of these programs, they'll be considered a low income customer for purposes of this 30% subscriber low income subscriber requirement. And then in C, this is where this is the language that's proposed by the joint commenters that allows for self-attestation of the customer's income and household size to qualify as a low income subscriber. So the commission would create an attestation form.
So,
that could,
Mr. Chair?
Commissioner Fishman.
Yeah, this isn't a deal killer for me, but the one change that I'm not particularly happy with is this self-attestation. And I'll just give my reasons real quickly. We don't need to spend a lot of time on it, but I'll just voice my concerns. We just went through COVID support from the federal government. And basically, out of $4.6 trillion in benefits, they're now saying that about 30%, or about $1.5 trillion, was fraudulently obtained. And that was under circumstances where there was very little vetting. And basically there was a self-attestation, self-certification kind of environment. And when I see that, I see that it's not just the taxpayers got hurt, but that people who legitimately qualified could have been excluded. And I know the intent here in self-certification is to be sure that every low-income person can, fairly easily become part of this program. But my concern is that, we'll end up with a lot of false attestations, and that it may end up limiting folks who deserve to have access from having that access. And there's a couple ways this could be gained. One is, let's say a developer or a subscriber organization is having trouble getting low-income subscribers. They could quite easily pass the hint on to new subscribers, just self-attest to being low income and we can get you on board. And I would much rather have those organizations actually doing their due diligence to get folks who really deserve the opportunity on board. And so I think the intent here is to help low-income people, but I think it's going to do exactly the opposite. So that's my concern. And it seems to me that, we've got 1 through 6 there about other, if people are in those other programs, they're automatically eligible, is how I'm reading it. So it seems to me that it's not a difficult bar to qualify without a self-attestation or self-certification. So anyway, those are my concerns. It's not a deal killer for me, but I would prefer that that one thing be taken out, and I'll leave it to other commissioners to discuss.
Mr. Chair.
Vice Chair Hall.
Yeah, I tend to agree. I do agree. I don't tend to agree. I do agree with Commissioner Fishman. I mean, in Section A of the special subscriber provisions, that's subsection 15 in the rule. We have a very well-defined structure set out that names the different types of programs that can qualify someone as or pre-qualify a customer based on whether they receive Medicaid or SNAP or LIHEAP and those sort of things. I think that's very well defined. I think this provision that just says you can walk in and self-attest kind of is antithetical to the kind of structure that we're trying to provide in Section A. So to me, it just doesn't really fit. It doesn't make sense to me that we, on the one hand, would say you can just self-attest, and then on the other hand, say, oh, you have to prove that you're in one of these programs for low-income people. I don't think it's, I think this part should be struck, is what I'm trying to say in paragraph C, because it just completely undermines the other provision. And provisions are supposed to be able to be read in harmony, and I can't harmonize these two at all. They're just based on totally opposite premises for qualification. So I agree with Commissioner Fishman there.
Russell, because it might seem that this new Part C could be a substitute in lieu of Part A. And, we're including these programs that are tried and true and vetted. And what if we put a proviso that, for a customer that perhaps is not pre-qualified per Part A, may submit a self-attestation. That's one of my comments. And the other, is there any obligation to verify by a low-income service organization regarding the attestation? So I think those are two of my issues, but by itself, I agree. I think it could really trump all of Part A. And I think the team we went through, a great extent to really identify these established programs that represent pre-qualification. And so I'm not yet ready to strike the new C, but and I support self-attestation because, as everyone remembers, we were involved in the early implementation of the Emergency Rental Assistance Program. And we even helped kind of vet the online application process when it was being beta tested, and it became much too onerous. And what ended up happening was the U.S. Treasury Department's Inspector General agreed to a self-attestation and whittled down the application for emergency rental assistance down to one page. And so I certainly don't want to create an opportunity for fraud, waste, and abuse, but this does provide some flexibility. I don't think item C would be a predominant option that would be exercised, but I don't think it should be available in lieu of all of those programs, those pre-qualification programs in Section A. So Russell, you see some kind of a compromise here where we can maybe qualify Part C?
Yes, Commissioner Myers, I think, or Mr. Chairman, I think it makes sense to the language that I haven't seen is directly from the joint commenters proposed language. I think you're right. We should make sense to clarify if the commission retains this alternative, that it is an alternative. So we say a customer who does not
Qualify.
who cannot, yeah, who does not qualify under under subpart A of the.
Mr. Chair, can I just make a comment? I appreciate your concern about making sure we provide all options, but I would just remark that, for the pandemic-related loss of housing was an emergency for people to have a place to dwell in. And I think not being able to demonstrate any qualification to sign up for the option of getting into the opportunity to have community solar, I don't think that's equivalent to an emergency need for a place to live, first of all. So I don't know that that's a compelling, that we have a compelling reason to put in a self-attestation provision, first of all. And secondly, I think if we're trying to provide for self-attestation, it would still have to be based on provisions of subsection A or some other way of establishing low income need. So I don't see how self-attestation in and of itself would be a valid substitute or alternative for the provisions in Section A.
Mr. Chair,
Commissioner Fisher.
I agree with Commissioner Hall on this. I'm perfectly happy with the language as it is. I think the workaround you're trying to do pretty much leaves people able to self-attest. And I think it's just a matter of either yes or no. And what I think might be the right way to go here is just to reserve this issue. We can vote on whether we need an amendment to eliminate C or not, but we can do that at the end here when we're voting on the entire rule, which again, I think is terrific. And I think the team's done a great job with it. And this is certainly, as I said before, not a make or break for me, but a preference would be for me to eliminate C.
The only other option I can suggest if it does stay in is that we make it an interim pre-qualification until they can qualify for any one of the programs in Part A. But again, that presents follow-up and compliance issues, but there could be cases where folks want to participate, but they have not yet pre-qualified under those programs in Part A and would like to submit a self-attestation pending qualification under those programs listed in Part A.
Yeah.
But again, it presents follow through, and if there are low income service organizations that could handle that, I think that can be done. But I wanted to throw that out as a possibility to making this work and really have this as kind of an interim last resort for pre-qualification.
There might be something we can construct that does that. That does sound like it might be doable, particularly if there's some organizations, service organizations that represent low-income folks who feel they can put together the case for someone who does a temporary self-attestation.
Yeah.
I can mull that while we go through the rest of this, and maybe we can come up with something. Maybe not. We'll see.
Okay,
And Mr. Chairman, I just want to make sure that to provide a clarification, or maybe a reminder of what this issue goes to. This is not about, this self-attestation option really isn't for the benefit of the low-income subscriber. It's for the benefit of the subscriber organization, because it helps the subscriber organization meet a requirement of the act that applies to subscriber organizations, which is that they attain at least 30% enrollment in any particular facility by low-income customers. And of course, they have to prove it in some way. So this assists them. It doesn't go directly to the issue of, how many low-income subscribers there will be. Although, as Commissioner Fishman noted, it may affect that, because, if this makes it easier, if it ends up resulting in, fraudulent attestations and people who are not low-income customers being counted toward that 30% requirement, that may, it may actually end up crowding out some actual low-income potential subscribers, because the subscriber organization may not pursue low-income customers beyond 30% requirement.
Yeah.
Our selection criteria actually encourage, by providing special weighting for points to bidders, subscriber organizations who go beyond that. But I think the 30% is a floor, so it's not a ceiling. But as Commissioner Fishman said, subscriber organizations will be motivated strongly by the requirement in the act to get to 30%. And to the extent that some of them may be some of these may be fraudulent, then it will crowd out low-income subscribers. But if a subscriber organization is committed to getting as many as possible, then there will be some fraudulent ones counted toward 30% and some real ones, and they may go well beyond 30%. I just wanted to clarify. I don't think I clarified that at all. I think it's what it is.
So Russell, Mr. Chair.
Commissioner Fishman.
Russell, that really is my major concern, is that I want those subscriber organizations to be motivated to get legitimate low-income people to fill that requirement rather than fakes.
Yes.
And I think when we have self-certification, we're creating a really easy way to game the system, potentially claim more points, but also not create the motivation for those developers to go out and find the low-income customers and make sure that they do get involved. And to me, that's kind of the main purpose of that special subscriber provision.
Yeah.
So that's where I get hung up on C. So,
Mr. Chair.
Vice Chair Hall.
Yeah, I just, I had that same idea, and I just want to say so, because I think if we let subscriber organizations rely on a self-attestation, we're just asking for trouble. We're just allowing a laxness in the process that subsection A is designed to avoid. And I just think under these circumstances, where this is not an emergency. I believe low-income people should have the same opportunity to get an opportunity to use clean energy. But I think it's undermined by allowing someone to just simply self-attest. And if they're gonna base their self-attestation on some later qualification pursuant to, say, the categories in section A, then what's the point? Except to allow a subscriber organization to pad their application and then maybe have to have it re-examined once you throw out the self-attestations that are not valid. So I think it creates more problems than it solves personally. I appreciate the motivation for trying to put in a provision like that, but I could just see more problems arising. And I think it would be an avenue that would require a lot of careful examination on the regulator's part to make sure that fraud, waste, and abuse was not being carried out, as you had mentioned. So anyhow.
Okay, all right. Then we'll, as Commissioner Fishman suggested, when we're done going through all the recommended amendments to the rule, we can take action on some of these individually.
Yeah.
I'm not going to fall on the sword. If you all want to strike it, that's fine with me. And if that qualifier there is not acceptable, then we can decide whether or not to keep that new Part C in there.
Yeah, well, I don't think the phrase that Russell put in helps at all, because it just says if you don't qualify under A, you can qualify through self-attestation, which is the whole section so it preserves all the language that I find objectionable.
Commissioner, that you're correct. That language was not aimed at addressing the concerns you've raised. Mr. Chairman had suggested making it clear that C is an option available only to those to whom A is not available. But it does not address any of the concerns you've raised. I just was to address what Mr. Chairman had said.
Well, then I don't know. I don't see the point, frankly.
Okay, let's deal with it now instead of kicking the can down the road. It's in there now. I'm entertaining any motions to strike the new Part C from this. We don't have a general motion. We can deal with it now or wait till we have a motion on the floor and then a motion to amend, whatever.
Mr. Chair, I will make a motion to strike Part C from subsection C from 17.9.573.
I'll second.
Okay, we have a motion and a second on the floor. Any discussion on the motion?
Mr. Chair,
Yes, Commissioner Byrd.
just thinking devil's advocate on this. Is there any situation where a project may not be built because there's say a majority of low income homes, but not enough to justify the project? And here's what I'm thinking, just to further that. There's a provision in the school lunch program that if a certain percentage of the families fall below a certain income level, then the whole school qualifies as subsidized lunches. So it doesn't matter that my kids come from a higher income family, their meal is subsidized because the majority of the community is subsidized. Is there a reason why a project would not be built if there's a few homes that can't qualify and therefore the whole project gets scrapped? And I'm just asking.
Commissioner Byrd, that's a very good question. I'm glad you asked that, because I'm going to try to describe how the 30% low income subscriber requirement will actually play out. I really wish Art were here, but I think I've got a sound enough understanding of it. And by the way, I also have Christopher Hall available to act as an Art stand-in in case he has any input on this. But this is how the low-income subscriber requirement for subscriber organizations for each facility will probably play out. The projects will be selected by the program administrator based upon program criteria, by the program selection criteria. That does not require that the 30% subscriber minimum requirement has been met, and the provisions with regard to awarding extra points are not for going above the 30%, are not based on an actual achievement, but a commitment that goes above that. And the reason for that is this, and apparently this is true of basically all community solar programs. The project selection is done before the subscriber organization begins their subscriber recruitment efforts in earnest. Some may begin the process beforehand, but according to Art, the projects will almost entirely not have completed that process at the time of selection. So there will be projects that will likely drop out after they've been selected by the administrator during the interconnection application process, because during that process, they'll also be doing most of their recruiting of subscribers and trying to meet that 30% low-income subscriber minimum. So those are actually two of the big reasons which, as Art discussed a few weeks ago when the commission was considering the order adopting rule, that we'll expect that some projects that are approved by the administrator or ranked highly by the administrator might drop out subsequently, which is why we have the wait list that of projects that'll come in behind them. The procedure is that if we don't require the recruitment to be done before the project is selected. I think it could take quite a long time. So in terms of preventing a project, it won't prevent, failure to meet the requirement won't prevent any project from being selected, because the requirement won't come into it at that point. There may be developers who anticipate that they will not be able to meet the 30% requirement unless they have self-attestation. They might voluntarily, not submit a proposal for that reason. We wouldn't know that if they did. I do wish I had Art here, because he could tell you possibly how common that is, but that's how it would play out, is that maybe some developers would say, if I can't do if I can't do self-attestation, then I'm not gonna, there's no way I can meet the 30%, just based on their own experience. And so I'm not gonna submit any projects, but we wouldn't know that, because that would happen at a stage before we see anything.
So, Mr. Chair,
Yes, Vice Chair Hall.
I'd like to ask, what's the source of the language that Christopher Hall put on the chat? Is that from the rule or the statute?
Mr. Chairman, Madam Vice Chair, that is from.
Yes, Christopher Hall.
Sorry. Just to respond, that is from the rule. It's if Russell would scroll up to subsection B immediately prior to what he's looking at. That's where that language is, and it answers, I think, the question of what would happen if the subscribing organization was not able to meet its carve out.
Yes.
Subsection B of what section now?
You should see it now. It's 14 registration. That's B. And so in other words, what this is saying is that it's not going to be a prerequisite that the project has met the recruitment goal before the project is selected, but it is a requirement of the act that has to be met at some point. And one of the things that has been objected to in our rule is that this subsection B is somewhat open-ended as to how the commission will address a failure or a long delay in meeting that requirement. But I am here to, again, recommend, as Art and I did before, we need to leave this open-ended. We don't know how long it's going to take to recruit subscribers, period, but to recruit subscribers that meet the 30% low-income subscription minimum. This allows for some flexibility. Reporting, we'll be monitoring it. And, there is the possibility that a subscriber organization that fails to do so within 1 year. No, 1 year. That's, I mean, that's how long it could take to recruit people after a project is selected and interconnected, or approved or is undergoing interconnection. To recruit subscribers, including the 30%, the commission may revoke the authority to operate and say, well, this project's not going to go forward. But of course, some of those projects might already be somewhat interconnected. It's a difficult situation, but that's just the nature of community solar.
Well, Mr. Chair, I'm sorry, Mr. Fishman, I just wanted to follow on that because I was wondering where the source was. But I mean, that seems to raise another batch of problems, wherein if we have somebody who, can, or for a period, some short period of time qualify, a subscriber organization can qualify their project for low income and then can't support it thereafter. I mean, what do you do with them? I mean, if have they already been able to go ahead and build their project in the interim, or how does that play out? How do we expect that to play out?
Commissioner, I truly wish I had Art here to answer that question. Because the fact is, whatever order you have these there's interconnection, recruitment, approval of projects, those three events, whatever order you put them in, there are problems, that are potential problems. The way what has been adopted by the commission is that selection of projects comes first. And so there will be projects that are selected that will, and Art did talk about this during the previous discussion, but that will be selected under criteria and ranked very highly that won't be able to pay the interconnection, or maybe even the interconnection study costs. They'll drop out on that basis. We expect that. And Art even said at the last, at the meeting in which the order adopting rule was discussed, that he actually expects that more projects will drop out due to an inability to recruit subscribers, period, and especially low-income subscribers, and meet the 30%. Then we'll pull out because of the interconnection application issue. We're expecting hundreds of applications, or Art is. So there will be plenty to replace those. But yeah, it creates a situation where, but the reason the team recommended and the commission adopted that procedure was to get the request for proposals process underway, because otherwise we might have to wait an additional year to, if we included that as a minimum eligibility requirement, that a project has already met 30% subscription. Well, there are two problems with that, because one, they'd have a whole bunch of subscribers who still might not end up with a project, even if it's selected, because they might pull out because of interconnection. And those three events, whatever order you put them in, there are difficulties, and this is an issue. But like I said, whichever way you do these, you have issues. Does that make sense?
Chair?
Commissioner Fishman.
Yeah, just a couple things that I'd point out. First of all, and Russell, tell me if I'm wrong on this. If a developer doesn't get enough subscribers, they do have a little bit of a backstop in that they automatically sell that power to the utility at avoided cost. Am I correct about that?
Yes, there is a provision in the Act for unsubscribed energy, so that the facility can produce all of the energy that it produces according to the sun,
Okay.
and gets
So
compensated to the extent that it's unsubscribed.
Yeah, so there is some protection there for the developer. The second thing I'd point out is that, Christopher, thank you for putting up that language. I'm really happy that it says at the commission's discretion, because I'm really having a hard time imagining the commission shutting someone down who already has a pretty substantial number of subscribers. And that the commission supports community solar. So I would imagine at the commission's discretion, in most cases, we just try and find ways to help folks get to 30%. We wouldn't shut them down or do something really stupid. So anyway, that's how I see it playing out.
And Commissioner Fishman, that's why we did leave that somewhat open. I mean, I'm just going to say, I don't have Art here, so I'm going to repeat what he has said previously, which is that like he said, we do expect that projects that are selected in the process, some of them are going to pull out afterward due to interconnection problems and due to recruitment problems, particularly with regard to this issue. But if you make them do those things before they're selected, then you create other problems, because then you have the utility having to consider hundreds of interconnection applications for projects that won't be selected. So if you flip the order of those, that's a problem. And if you require that the 30% low income recruitment is done before project selection, well, look at what we put here. 1 year. We're giving them 1 year, because that's a reasonable amount of time that it might take to recruit subscribers, particularly the low income subscribers, and qualify them. So we don't want to put the selection process off for an entire year. So that's why I'm saying, whatever order you do these things in, there are problems that arise. But this is what Art had recommended.
Well, and so I think the important thing here is that the commission not take a punitive approach, but help them get their approach in the way that this is regulated.
Yes, Commissioner. And the rule does that, of course, in subsection 15, because the commission is contracting with, I don't know if we've already executed the contract or if that proposal is still out, with a service provider who will partner with community organizations. We're going to help the subscriber organizations meet this and qualify people. So we will help. And in terms of penalty, and we'll be monitoring with reporting, and is included in this rule that the commission may impose penalties for a subscriber organization that fails, up to and including revocation. But it's just in the commission's discretion, because Commissioner Fishman is correct. It's unlikely the commission is going to want to do that, but you have to warn them, and maybe that will help motivate that that's a possibility. So, but Commissioner Hall, you're absolutely right. This the order of those three events in this rule, creates some potential practical issues. But every ordering of those three events creates potential issues. So you just have to choose which set of potential issues you want to deal with. And what the commission has adopted is Art's recommendation that get this project selected. That way you have a limited number of interconnection applications, only those for the selected projects, not for all 900 that we might receive. And two, the selection process can go forward, quickly within this year, instead of waiting until we see which projects are able to recruit. So I hope that answers your question, Commissioner Hall.
And let's just go ahead, Vice Chair Hall.
Well, I just wanted to ask Russell if he knew, or maybe Christopher Hall would know, how whether this has been a problem in other states that are already doing community solar, if they run into problems with that, or are they? I assume the work you've done, the team has done, has probably examined other states' programs, and I just wondered if they, what you could share with me about that. I mean, has this language been informed by the knowledge that once a subscriber organization commits, it's much more likely that they'll be able to get low-income folks? I mean, what do we know? What can you tell me from the research, or maybe Chris would know if we've looked into what's happened in other states?
Well, I'll let Christopher answer, but I'll first say the way we've ordered the process is as per Art's recommendation, and Art's advice is always informed by what's happening in other states. He's always, I can't tell you exactly what he said, but he's always talked about, how it works practically in other states. So the approach, of starting the selection process is definitely informed by Art's experience of what's happening in other states. I don't know, Christopher may have more to add.
Mr. Chair, Madam Vice Chair, Commissioners.
Go ahead, Christopher.
Thank you, Chairman. Madam Vice Chair, my understanding is that most other states don't have a per project carve out, but a total carve out for the total allocation. And so what that has resulted in frequently is everybody not doing any low income subscribers until the very end of the project period where, whether it's 10% or 20% or 30%, somebody starts throwing up a project to fill that 30% carve out because it's a total allocation carve out as opposed to a per project carve out.
What's that phrase you're using? Per, what is that word that you're saying?
A per project. So
Per project. Oh,
New Mexico's community solar statute requires a per project
mhm.
30% carve out. So every single project has to have a 30% low income subscriber base. Whereas a lot of other states, in my understanding, and if my recollection is correct, many other states have a total allocation carve out. So as opposed to each project having to be devoted to 30% low income, 30% of the total 200 megawatts would have to be devoted to low income carve out. And then it becomes sort of a Russian roulette to see who has to fill that slot, as opposed to each developer having to fill that slot. I would also add that one of the useful things I think in this statute is that it allows low income service organizations to also be part of that 30% carve out. And so, and that definition is somewhat broad. So conceivably homeless shelters, food banks, food kitchens, soup kitchens, churches, other community-based organizations could also qualify for that 30% carve out. So it's not just individual subscribers. So I think that's going to be a route that some of the developers will take. And I'll stand for any further questions.
Vice Chair Hall, anything else?
No, that's very helpful. I remember a long time ago reading that and I forgot that provision, and that puts a different emphasis on this issue in my mind. So thank you very much for explaining that, Mr. Hall.
And I just want to offer up some general sentiments from some of the stakeholders that participated in this. And they felt like that we shouldn't come up with an overly intrusive and burdensome process to qualify or pre-qualify low-income subscribers. But looking at what we have already in those lists in Part A, all those are a pretty good list of programs that are well established. We are New Mexico. Unfortunately, we probably lead the nation in per capita federal assistance in many of those programs listed in Part A. And so I think Part C it's an enhancement. I still think that the lion's share of the categories for pre-qualification are in Part A. So I think we've spent enough time on this. We have a motion on the floor and a second to strike the proposed language, the new language in Part C. Is there any other discussion on that motion?
Well, Mr. Chair.
Mr. Chairman.
Commissioner Vicente Aguilar.
Thank you, Mr. Chairman. We have many questions, and we are also at a moment where the highlight, the passage of this particular rule, and the leader of the group is not present. So I have a question for Russell. Do we need to take action on this rulemaking today?
Commissioner Vicente Aguilar, yes. Unfortunately, the statute, the Public Utility Act, which provides this motion for rehearing procedure, which I advise the commission, it would apply to this act because it applies to, all acts regarding electric utility, in OGC's opinion. It requires the commission to address motions for rehearing within 20 days of their filing. Otherwise, they are deemed denied by operation of law. So this is the last chance for the commission to consider, because I think 20 days is either today or tomorrow. So yes, these things have to be decided today.
Thank you, Russell. Mr. Chairman, that was my question, and that's it. Thank you.
Okay, any further discussion? The motion?
Yeah, Mr. Chair.
Yes, Vice Chair Hall.
Well, I don't know how Commissioner Fischel will feel about this, but I think I want to amend my motion to preserve the language in C, but amend it to say a customer may provisionally qualify as a low-income subscriber by signing a self-attestation that the customer's income and household size qualify the customer as a low-income subscriber, comma, as long as the customer can, Russell can help me with this language, but the idea would be as long as the customer can provide some sort of qualifying information within a certain period of time. I think if we make it provisional, that might be the solution. You had mentioned that earlier, and I think if you can make it provisional, that at least helps the developer get a little bit more information about who would possibly be low income, and then they have to establish it. But I think the fact that this impacts every project that's going to be proposed gives it a little bit more urgency.
Well, Commissioner Hall, one thing I would note is that this, as it is, and this was how it was recommended by the joint commenters, this is not only a different method of providing a qualification, but it's different criteria, because the first option A doesn't require looking at the customer's income and household size. It would be a confirmation that the person is actually, by third party, that the person is actually enrolled in one of these programs. Whereas the self-attestation doesn't require that the customer be enrolled in any of these programs. It just would be a self-attestation that the actual income and household size qualify as
right.
allowed to qualify. If you refer then to subpart A.
No, I'm not suggesting that you do that.
Okay,
I'm just suggesting that they have to at least establish their income with some sort of documentation. If they have, if they have no job, I guess they could self-attest to no income.
Okay, I see.
That's what self-attest was referring to.
You're correct, then I understand that. Okay.
Yeah.
So as long as the customer can provide sufficient documentation, confirming documentation within what period of time?
Well, I don't know. I don't know.
3 months, does that make sense?
Sure. Yeah, 90 days. Christopher Hall says.
So I won't say can provide, I'll say provides. As long as this customer provides, actually have to do it. As long as the customer provides sufficient confirming documentation, Yes, highlight that blue. I just want to keep everything distinct. All right, so Mr. Chairman, if you,
Vice Chair Hall, what is
I
that?
don't recall where we
Is that
stand with the
language-
motion.
It's fine.
Is that language
It's-
acceptable to you?
Yes,
Um,
yes.
Commissioner Fishman was the maker of the motion to strike, so.
Oh, wait, I'm sorry, Mr. Chair. Excuse me, Mr. Chair. He left out a word. A commissioner does not qualify, may provisionally qualify. You see where I'm, Russell? And then rather than say as long as, you could say until the customer provides sufficient confirming documentation.
We make pretty good sausage here at the PRC.
And then I would add, well, because we're not saying as long as, I need to make it clear that a failure to do so. I guess that's clear enough. Obviously, a failure to provide sufficient confirming documentation will result in the provisional qualification disappearing. So, okay. All right.
So Commissioner Fishman, Vice Chair Hall is withdrawing her second of your motion to strike and adding some additional language. You see this as a friendly? Commissioner Fishman, are you there?
I am here. Sorry. Yeah, I think this is a nice middle ground that puts the brakes on abuse of self-attestation. And I think this is a very reasonable proposal.
Okay, instead of reciting the motion, it's a friendly amendment to avoid striking the proposed initial language of Part C and add some additional qualifying language per Vice Chair Hall's suggestion. So anything else, any other discussion on this amended Part C?
Mr. Chairman,
Yes, Commissioner Vicente Aguilar.
I think we need to go through the formal process. Commissioner Fishman needs to withdraw his motion, and then we need to hear from Commissioner Hall with her amended motion. Thank you.
Very well.
Okay, Mr. Chair, I withdraw my original motion to strike section C.
Okay, and that motion fails for lack of a second. So is there a new motion to adopt the revised language of Part C?
Yes, Mr. Chair. I propose the language that we have written on the screen, which says a customer who does not qualify under Subpart A may provisionally qualify as a low-income subscriber by signing a self-attestation that the customer's income and household size qualify the customer as a low-income subscriber, comma, until the customer provides sufficient confirming documentation within 90 days of providing the self-attestation. That's my motion.
Okay, great. Do I hear a second?
Second.
Okay, second by Commissioner Vicente Aguilar. Any discussion on the motion? Russell, roll call vote.
Commissioner Hall,
Aye.
Commissioner Vicente Aguilar,
Aye.
Commissioner Fishman,
Aye.
Mr. Chairman,
Aye.
and Commissioner Byrd.
Aye.
Mr. Chairman, the vote is unanimous to adopt the subpart C as amended, as shown on the screen right now. As per
Okay. Let's
Commissioner
go ahead and
Hall's.
finish this up, but we still need to adopt the overall order and the amended rule.
Yes, and we're quite close to the end. I'll just quickly go through the other recommended amendments or revisions to the rule that the team recommends adopting. Let's see here. Okay, so those, again, we're still within the group of proposals made by the joint commenters and their joint motion, that the ones that the team recommends. So we've gone through the self-certification option. The second one that the team recommends adopting is right here in the same section, which is in subpart B.
Russell, excuse me, can you continue displaying the rule?
Oh,
just-
I thought I was. Sorry,
No.
let me do that again. Okay, let's see here. Okay. So just above the subpart that was adopted just now is subpart B, which allows a multifamily affordable housing project to pre-qualify its entire load as a low-income subscriber. We remove this language with consent of all tenants of record. That is Art. Art recommends removing that. That's a very burdensome requirement, and he doesn't support. He didn't. He agreed to that should be removed. So the housing project itself could just prove to the commission that its subscribers that its tenants are low income. So that's one that we recommend approving, because that would be an untenable and very difficult, unnecessarily difficult requirement. The next change that is recommended by the joint commenters that we would have the commission adopt. Let me see, I'm just going through. And if you're following along, I'm on page 10 of the memo. Would be the joint commenters proposal to the joint. Let me just make sure. Okay, it would be to remove the 20% cap on the wait list. Let me get to that part of the rule here. Okay, as you will recall, I've mentioned the wait list today because there is anticipated that some projects that are selected to go forward to the interconnection application process, will drop out. The rule as it's written provides for a wait list. Where's that? Okay, so subsection 8H, as you can see of this 12, which goes through the entire process. H would creates a wait list that for projects that will be ready to fill in for selected projects that drop out. The selected projects are the highest ranked projects in the ranking process, to the extent that they fill up the allocated capacity cap for each utility. In other words, that's how the size of the selected list of selected projects, that's what determines the size. So up to the cap that each utility in terms of capacity has been allocated. So the waitlist provision that the commission adopted in their adopting rule had a 20%, would be 20% of that size, essentially. The waitlist would be 20% of the size in terms of capacity per utility that as the selected project list. And the joint commenters and some other commenters said that's way too small, because for EPE, for example, 20% of their allocated cap would be 6 megawatts. And since the project limit, the size of facility limit is 5 megawatts, and many projects will be anticipated to go right up to the limit. That's one project. So it could be just one project on the wait list. And so they say, why not make sure you have a wait list of people ready to projects ready to substitute that's larger than that, or doesn't have any cap at all. Well, if it didn't have any cap at all, you'd have a wait list of hundreds of projects probably. So this would, the team's recommendation is to raise that 20% cap to be the same size as the selected list. In other words, 100%. So this language would just say the wait list will be will include projects with combined capacities of each utility equal to the allocated cap. In other words, the wait list for each utility's to substitute projects will be exactly the same size as the selection list. And that's, that would mean if every single project on the selected list pulled out, you'd have enough on the wait list to replace them. Okay, so I'll move on from that. Let's see where I swear we are near the end. There's just a few more to discuss. The utilities objected and to the provision of the rule that limits their participation as bidders, as subscribing organizations. Apparently in other states, so the utilities participate in community solar projects as bidders. They often will, I guess they create affiliates that act as subscriber organizations in the process, in order to participate in a different capacity as actual providers of community solar facilities, as subscriber organizations. And the commission had included, and this is in subsection C of 12, that utilities and utility affiliated bidders would be limited to a maximum total of 20% of the capacity in the selected projects list. Now, actually, let me correct that. The consideration of bids, the utilities could only, and utility affiliated subscriber organizations could only bid up to 20% of the capacity. They can only bid up to that point. To that capacity cap. And what the utilities objected to that as, discriminatory toward the utilities in a way that's and unjustified by the act, because the act doesn't have anything about that. And what REIA, so the utilities want to get rid of it entirely, but what the REIA, what the joint commenters recommended was just make it applicable to all types of bidders, to all subscriber organizations, so that essentially no developer, no subscriber organization can bid more than 20% of the capacity. And Art thought that was a good idea. It's non-discriminatory, obviously. It's not directed toward the utilities. It's just to say that they would serve the purpose of a diverse marketplace of developers, which is something under the act that definitely can be justified as a purpose, supporting the marketplace of a diversity of providers, essentially. So, and then I'll move on from that. Okay, just a couple more. Let's see. Oh, well, among the selection criteria, there are a couple of changes. One is to correct an error. Let me get that in front of you here. Oops, sorry. Got it wrong. Sorry, just have to get the document here. Here it is. Okay. So you're still seeing the rule. Is that correct, Mr. Chairman? It's still on the screen?
Yes.
Okay. So the team recommends that a couple of the selection criteria be revised. One is for a mathematical error. Where's that? It's in a subsection in 5B, which you have in front of you now. The amount of points for each level of commitment to direct billing of low-income customers didn't add up to 8 points, which is supposed to. So they would just change a 4 to a 2, pretty elementary, and something we had actually discovered as team members before this motion was filed, which would have been taken care of by Narada, but we can take care of it here. And then the other is an actual substantive change, but a minor substantive change with regard to 7A or 7C, which provides 2 points.
Russell,
yes.
Russell, excuse me.
Yes.
Commissioner Byrd has a question.
Okay.
Sorry, Russell. Go back to 5B. You made that a 24. You didn't mark out 4.
Commissioner Byrd, what that actually is when it comes to track changes, I did strike out 4, but when you strike out a 4 in track changes, it goes right over the bar in 4. So it looks like it hasn't been eliminated.
Okay, so when you accept changes, it'll fix. I see that now. Sorry.
It'll
Thank you,
just
Mr.
be
Chair.
No, I think it's funny that happens in Microsoft. It just matches exactly where the bar is. So it looks like
Thank you,
nothing's
Commissioner.
happening.
Go ahead, Russell.
So 7C, the rule awards 2 points for a project that's received a favorable analysis in terms of the site as being a site that it won't, a site that does building there will not, interfere with an area that's archaeologically or culturally important. And the rule originally just had, and then you had to have an analysis from the Department of Cultural Affairs, and the joint commenters had actually come up with these selection criteria that the commission adopted. And they say they subsequently have learned that it's quite rare. It's not routine at all to get such an analysis. So this would allow for qualified independent experts, such as an archaeologist, on contract, to provide that analysis to get those 2 points. Let me see if there's anything else here. We're getting very close to the end, I swear. Let me just get to my memo. Just want to go back to my memo here. Okay. That was it for the joint commenters recommendations that the team recommends adopting. I just want to see what else I need to discuss here. Sorry, I'm just going through the memo. I'm on page 10, and I think I can eliminate some of the discussion just because, for reasons of time. And take a look at this. Okay. Oh, the city of Las Cruces had objected to the fact that the rule requires as a minimum eligibility requirement for consideration in the project selection process that now I'm at 12B, 12B3, that as the city objected to the requirement that the bidder to be considered in the process have completed a utility pre-application report or a system impact study, for interconnection. We discussed this with Art last week. He thinks it's an important requirement because it's also a very minor requirement. A pre-application report is something that the applicant or the bidder, the subscriber organization can obtain within a matter of days from the utility. We actually reviewed this report yesterday in a team meeting. One of the reports that the utilities provide. And it's just very basic information. It doesn't really tell you much of anything as to whether, how much, it doesn't tell you anything about how much it will cost to interconnect the project. It's a very preliminary report. So, but Art did believe it was worth requiring of any bidder. Like I said, it's minimal. It's like a 2-pager. And the revisions that we made here go to a different issue, which is that what we really want to have as a requirement is this type of report and nothing else. There's no way that the system impact study is going to be, I don't think any bidder is going to want to provide that. That's a much more involved analysis. And that also, I think, would require that they have already filed an interconnection application, that the utility is proceeding under one, which is what we're telling the utilities they don't have to do. So it would just replace the system impact study as an option with an equivalent analysis. In other words, because Art said the utility, each of the 3 utilities can provide either a pre-application report or something that's very close to it, an equivalent, within a couple of days of being requested by anyone who's going to be proposing the project, and it's very minimal. So he would retain it as an eligibility requirement over the city's objection. So if there are no questions, I'll move on.
Mr. Chair.
Vice Chair Hall, yeah.
So Russell, then that remaining phrase, an equivalent analysis by the utility, don't you want to say an equivalent report? Because, the pre-application report is just a report presented by the bidder. It's not an analysis in the way, a system impact study would have been an analysis, but it's just a report. So don't you think
That's a good point. That is the word that Art used, but I think you're right. An equivalent report is a better way to put it because for the reasons you gave. So I would accept that. Yeah. Okay. I'll just make that change here. And let's see. Very close to the end, I swear.
Okay, any objection to that change? Any objection? Okay. Continue, Russell.
Okay. Where are we here? Okay. Should make sure I'm covering all this. Okay. US Solar, one of the non-utility commenters, recommended revisions to the low-income qualification part of the rule that we're just looking at in 15. And one is for clarification. And the other, let me get the rule. Okay. We go down to that portion of the rule. Okay. He wanted a clarification. Christopher already mentioned this, that both low-income customers and low-income service organizations can be counted in toward the 30% low-income subscriber requirement. And that's true. The Act itself provides for that. Just to provide a clarification here, what the low-income service organization is a term that's defined in the Act. I feel like maybe I should get the Act language on that. It's an organization that, as Christopher said, is a fairly broad definition. It's an organization that serves low-income members of the community. I'm going to just quickly get the Act in front of me. So I just want to read this definition, and then it'll help you understand this portion of the rule. I'll just quickly get it in front of me because I just want to read that language. Sorry for the delay. Here we go. Okay, so the Act, I'm reading from the Act now, defines a low-income service organization as an organization that provides services, assistance, or housing to low-income customers and may include a local or central tribal government, a chapter house, or a tribally designated housing entity. So to meet the 30, that does under the Act. There's a specific provision of the Act that includes service organization something that can go toward the 30% low income requirement for a subscription. So if such an organization decides to hook up to a facility, become a subscriber, its load, its usage, its capacity, it's 100% use over an annual period of a year will count just as an individual customer's own usage would qualify. They both qualify and go to the 30%. And so the rule adopts the language that US Solar recommended for that part of the rule in subsection A. Just that change from subscribers to customers is something that helps clarify. I'm not going to go into the detail, but under the Act, US Solar asked for that to clarify that under the way the terms are used under the Act. I know you don't want to go into that, but anyway, this just clarifies that yes, both can qualify. And then subsection D, US Solar recommended that the commission that there be separate criteria for qualifying a low-income service organization as a low-income service organization for the purpose of meeting the 30% requirement. We've just discussed in detail how an individual customer or a household can qualify. A low-income service organization is a very different position. Obviously, it's not an individual low-income customer or a household. It's it's an organization that serves them. So U.S. Solar recommended that this rule include qualification criteria created by the commission, but they didn't recommend any. If they had, I probably would have just included those. But what I've done here, and again, this is sort of me acting on behalf of the team because I had to fill something in here. The team did recommend that we include criteria, but then no one had any. So what I'm doing is saying, I think the definition itself is enough that I just read to you. I don't think any additional criteria for determining whether it's a low-income service organization is needed. The definition is enough. Then this is not something where self-attestation is needed. Someone would just simply need to contact the organization and get some kind of, verification of some sort that the service organization, serves low-income customers. So I don't know if there. I just said that I just put in language saying that the organizations need only fit the special definition that I just read. I can take any questions on that. I think it's sufficient, the definition, but the commission could come up with qualification criteria right here and now, if you would like to.
Any questions for Russell? Okay, Russell, is that pretty much the end of all the proposed amendments to the final rule?
Yes, it actually is. Those are the ones that the team has addressed. And then, as I say in my memo, I'm at the top of page 11, the last page. The team recommends that the commission reject all the other recommendations made by the non-utility movements, just as the team did with regard to the utility motions. We discussed the ones we thought were important to discuss, whether they're rejected or adopted. And then there are some other recommendations that were made that aren't even addressed for the reasons I discussed. The volume of the motions that had to be dealt with, and the fact that the commission doesn't have to, under the law, doesn't have to address every single recommendation or proposal made in motions for rehearing, particularly when the commission considered a record of hundreds and hundreds and hundreds of comments that included many of these recommendations. Now, Commissioner Fishman has suggested to me that I at least list for the commission the proposals that are not discussed here, and I can do that.
Mr. Chair,
Vice Chair Hall.
I had a question for Russell about one item that I saw in comments by one of the non-utility entities who filed. And if I could just ask him this one question, because he might mention it in this list that he's going to provide to us, but I had a question about this one issue. So could I just ask that question of him? I wanted to basically know why it wasn't something that we discussed, unless maybe he's dealt with it in some way that I don't know. Could I just ask him that question?
Please go ahead.
Okay. Russell, in comments that were submitted by Power Market, they were addressing the assignment of points. They say they don't believe a bid should be awarded more points for making a commitment to source direct billed low-income customers, as in doing so may result in unintended harms. And he was comparing direct billing low-income customers as opposed to utility consolidated billing, which I guess we don't have here. Do you remember that issue? And can you tell me why we haven't incorporated any of these concerns?
That's a very good question, Commissioner Hall. Power Market did spend a lot of their time in their motion discussing that. And the reason it's not addressed, I could have something specific, I could add specific language, is that the commission in the rule rejected the proposal that was made by a number of commenters for for consolidated billing, which would be which would put subscriber organizations charges, their own charges to their subscribers on the utilities bill. The utilities vociferously objected to that because the only billing requirement that is made of the utilities under the Act is that they include the solar bill credit on the bills of any ratepayers who are also subscribers, because it's an offset to the costs of that the subscriber has to pay, and they didn't want to have any other charges that a subscriber organization might be charging its own subscribers, because the utility is now responsible for those, doesn't have control over those, and it hasn't contracted for that. It would be, and also they said it would be confusing to subscribers. And I agreed with all. The team agreed as well, and the commission did adopt, in the orders adopting rule, rejected consolidated billing for all those reasons. And since Power Market's direct billing issue here seemed to rely on the commission also going back and rejecting consolidated billing, it simply wasn't addressed in this order. And you might consider that somewhat arbitrary, because we did address some other proposals that were recommended for rejection. It was simply a matter of trying to keep this within some kind of limits. And because this would be contrary to what I think is a pretty major decision made by the commission not to reject consolidated billing, which is discussed in depth as a policy matter in the order, that we didn't really need to discuss this because we're not allowing consolidated billing. So this proposal is rejected for those reasons. But I can provide specific language in the order as well. It's just that with 9 motions, we did not feel we needed to address all of them in the order. The order would be about twice as long maybe as it currently is. And this discussion would still be going on for another 3 or 4 hours if we did that.
Well, okay, I understand. They just described us the scenario where low-income residents can be at risk or being challenged by the fact that the value of there's going to be variation in the amount of their credit. And I guess just because their budgets are tight, it's hard for them to be able to adapt to a varying bill. But
yeah, and I could,
guys have looked at it, I guess.
And they also mentioned, which I think is probably a valid consideration, that low-income customers tend to be underbanked or unbanked. They don't have access to banking. Although I would say I don't. Maybe someone knows more about this than I do. If they're paying a utility bill, so I don't know that there would be an inability to direct bill by a subscriber organization. If the utility can bill the low-income customer, why can't the subscriber organization? I mean, to the extent that they are billed by the utility, they should. I would assume they could be billed by the subscriber organization, unless there are special provisions outside of what the commission handles. And some, I don't know, financial provisions, something that allow for utility bills to be. I have no idea why there'd be a difference between the two. So these are customers who do pay a utility bill somehow. So they're at least have enough access to either credit or a bank account to pay it in some manner. And so I don't understand why the subscriber organization's bill couldn't be paid in the same way.
I don't know. I guess I just think it's an issue maybe you ought to keep an eye on. I mean, the language they have here in their brief, which I'd like to read, says, low-income residents are typically on a fixed income, and variability in monthly expenses can be particularly disruptive Since the value of community solar credits applied to their monthly utility bill will be variable, as such credit value is correlated with variable monthly generation of the community solar project. They may be asked to pay $27 in 1 month for the value of $30 of credit applied to their bill, or $90 in another month for the value of $100 of credit applied to their bill. While they would be saving in each of these months by nature of paying only 90% of the bill credit, these charges could nevertheless result in overdraft charges or insufficient funds for other critical monthly expenses. So I don't know. Maybe we should just, be aware that this is an issue and may follow it as time goes by. See if we need to address it.
Thank you, Vice Chair Hall.
Yeah.
Okay.
Mr. Chair,
Russell?
Mr. Chair.
Yes, Commissioner Fishman.
Yeah, just for clarification, I wanted to point out that many customers do pay in cash going up to a utility window each month, so that they don't necessarily have credit. Second, I'll agree with Commissioner Hall. Let's monitor this. The number of dollars such that it could create an overdraft or other kind of situation is pretty minimal. But, we should just kind of keep an eye on it and see if that indeed is the case.
Okay.
Thank you, Commissioner Fishman. Russell?
All right. So let me get to just mentioning the proposals that and the arguments that have not been specifically addressed today. I think I did. I'm going through P&M's motion now. I did discuss undefined terms. So I'll go back. I'm sorry. I'm looking through the list. I'm sorry I wasn't able to provide a comprehensive list of for this meeting of the unaddressed issues, but I can quickly summarize them. P&M had asked for the rule to include any instructions or guidelines, because the order adopting rule mentions that the commission will issue guidelines in the future as to how each community solar facility will achieve the 30% carve out for low income subscribers. This is one of those arguments and what the P&M argues is that this is something, an implementation procedure or effort that should be included in the rule, these guidelines. And really, this is going to be instructions that where the commission will be issuing instructions to the contractor, the service organization with which the commission contracts to work with community outreach program, community outreach organizations, to basically make this to assist the subscriber organizations. We need to this is something where it's not going to be policy making. It doesn't need to be in the rule. It's something that well, I guess I won't go into the reasons. I guess the point of this is I'll just mention that I'll just say we don't need to put that in the rule. It's something that we'll work out with our service organization, and I'll move on. Let's see what we have here. P&M objected to our sort of open-ended approach with regard to subscriber organizations' failure to meet the 30% low-income carve-out. We've discussed that at great length and why it should remain somewhat open. Let's see. P&M has for more specificity regarding production data. That's something that's not addressed here because there is this is a P&M asking for something more specific, whereas what's provided in the rule is sufficient. Anything else here? Sorry about that. I think that's it. And then with regard to SPS reiterated, in addition to making some of the same arguments about alleged procedural flaws, and other arguments made by P&M, SPS reiterated their what they had said in the comments about, that the commission should adopt a more stringent approach to regulation of the subscriber organizations. As you recall, what the commission has adopted is a disclosure regime, because disclosure is required. Disclosure by subscriber organizations to subscribers of the critical terms of the subscriber agreements. But SPS had advocated an approach that I think was followed and applied by Maryland, the state of Maryland, and their community solar program, which would be extensive regulation in terms of telling the subscriber organizations what terms they had to include, and a lot of specific requirements and proscriptions and prescriptions for that. So that is not addressed here because the commission firmly adopted a contrary policy in the rule. Let's see. I think that's it with regard to the utilities recommendations. With regard to the non-utility recommendations, I think we discussed the power market proposal. I'm sorry, Cypress Creek. Okay, Cypress Creek had a number of recommendations that are not addressed here. The first is that Cypress Creek was a commenter, a non-utility commenter that actually did favor changing the order of the proceedings in terms of requiring first that a project be prove that it can feasibly interconnect. In other words, that an interconnection study, a full interconnection study, which can be quite costly and take quite a bit of time, be conducted as a minimum eligibility requirement, where our current rule just has a pre-approval report because that's something simple and can be obtained quickly. But this CCR had said that there's the danger that projects selected in the selection process by the administrator will pull out when they actually have an interconnection study that shows what the cost will be. That's something, again, we've discussed and considered. The commission is aware of the downsides and the upsides of both, ways of proceeding, and this is what's been selected. So I'll move on. Yes. Okay. They just cohesion. The CCR also asked for that the commission require utilities to ease or remove capacity requirements that the utilities limitations that they impose on the capacity of distribution feeders and substations. This is beyond, I think, the scope of a community solar rulemaking. I think it's more applies to interconnection. I don't think they even provided a specific language for that. It's a highly technical issue that I think would be would be under interconnection. That's why it's not addressed. It's hardly comprehensible to me personally. So I think that's it. Because the other CCR recommendations are congruent with things we have discussed, such as co-location. And then I think the last one is, I'm sorry, I wasn't able to create a list. So I'm looking at the actual motions, but there's only one more, and I will be able to, and I'll be all finished. Okay, so Renewable Energy Industries Association in their motion for rehearing raised a number of issues, but most of them were covered under what's already been discussed to some extent. They recommended that that all prospective community solar project interconnection applications should be reviewed they asked for a rule provision that would state this: under New Mexico interconnection rules, rather than through the FERC's small generator interconnection process. This was an issue that was raised that Art had already considered, and I believe was something that just did not need to be addressed in this rule. There's a comment. They asked for clarification of the rule that tribal community solar projects do not have a selection process and are free to move forward with the current interconnection process now that the final rules in this docket are adopted. The act itself provides that tribal community solar projects, aren't subject to most of the provisions of the act, except the requirement that if they're in a utilities service area, the utility is required to process a solar bill credit. So it's clear from the act that that tribal projects are, they're exempt from all these provisions. I think that's it, actually. Yeah, I think I've covered everything, because there's some proposals made by in these motions that are on the same subject matter as things that we've addressed already. And so they're not really separate and distinct from these proposals that have been considered by the commission. I think I covered everything there. So I will take any questions.
Commissioner
Mr. Chair? Yeah. Thorough presentation, Russell. And if it sounded a little like you're catching up and maybe a little disorganized to the rest of the public, you were catching up with a ton of paper and submissions, and the team and you've done a terrific job dealing with it all and updating the rule. I also want to say for all those folks who submitted proposals and updates to the rule, there were some really good suggestions, and I'm glad we got them incorporated. And with that, I would like to move the order with the amendments and corrections that we've already made.
Okay, we have a motion on the floor. Do I hear a second?
Second.
We have a second by Vice Chair Hall. Any discussion on the motion? I do want to clarify that the amendment made to Part C of the special subscriber provisions doesn't require an amendment to the actual order. And what Russell just went over is basically mirrored in the order. And so what we're adopting is the order with Exhibit A that includes the amendments to the final rule. And under discussion, I just wanted to say a few words. I echo what Commissioner Fishman said about the participation and the feedback from the utilities and all the stakeholders. It's much appreciated. And I think based on the recommendations that we went through in great detail, we listened. But the fact of the matter is the legislative mandate in this rulemaking is unlike almost any other that has come before the commission, because it not only tasked us with finalizing a rule in almost record time, but it also tasked us with continued ongoing administration of the program. We've been transparent and exhaustive, proactive and inclusive in trying to build consensus among stakeholders here through the pre-rulemaking workshop, in addition to the legally required notice and comment period through the formal rulemaking process. There are issues that needed to be in the rule, and there are issues that need to be in the implementation docket, and that are decidedly not rulemaking functions, as they do not involve the commission's policymaking responsibilities. Trying to operate, administer, and monitor an ongoing program like this would be untenable absent this kind of flexibility. Otherwise, any small adjustment to any non-rulemaking implementation efforts would require a full rulemaking to amend the entire rule. And I want to remind everyone that it's important to note that the commission is required to submit to the legislature no later than November 1st of 2024, a report detailing the status of the community solar program, along with an evaluation of the effectiveness of the commission's rules to implement the Community Solar Act and to make any recommended changes. But we can't continue attempting to block the progress of community solar because there won't be any projects to report on. Most importantly, these unnecessary delays are hurting everyday New Mexicans who stand to benefit the most from the access to affordable, reliable solar energy that this rule will make possible and accessible. It's time to move forward on this, and that is what we are doing today. Any further discussion? We have a motion and a second on the floor to approve the proposed order and Exhibit A, which is the final rule as we've amended today. Any further discussion? All right, hearing none. Russell, roll call vote, please.
And Mr. Chairman, just to
Mr.
clarify
Chairman.
before
Yes, Russell, please offer a clarification and then we'll go to Commissioner Vicente Aguilar.
I was just going to say that I actually will make a slight revision to the order just to refer to the revised language for self-attestation, because even the commission rightly went through the language of the rule itself, the change in detail, but OGC, when there's an instruction that also requires a revision to the order to make it consistent with any changes made by the commission, we do revise the order accordingly. So just be a minor revision to the order. So that doesn't change the motion at all. Just to let you know, I will be making that small revision to the order.
Okay, thank you, Russell. Commissioner Vicente Aguilar.
Thank you, Mr. Chairman. I also would like to extend congratulations to the entire team and also Russell Smith to put all the responses, the filings, the recommendations, put it in focus for the commissioners to understand. And I appreciate that very much. I think we have cultivated an extensively conversation, and it took about 3 hours on the subject of community solar adoption of rules. And the reason that is because we come from districts that encompasses all classes of customers. And I think I'm proud of my colleagues. They understand New Mexico very well. And, we think about families, farmers that are like 3 to 4 to 5 hours away from Santa Fe. So how can they have access to these type of forward-looking policies, and to also establish a working relationship for communities that need to educate their customers? So I'm very proud of the whole process. And the most important part that I would like to say is that I think what we are ready to vote on is equitable. I think it's sustainable, and I think it's affordable for all customers. And I would like to say that, it's a long time coming, and I'm glad the state legislatures passed this legislation, because Native American communities, they have always leaned on all-encompassing spiritual ecology, and we're going back to that type of environment, and to discuss these issues near the state capitol to make the adoption of rules is very, very enlightening. Thank you, Mr. Chairman.
Thank you, Commissioner Vicente Aguilar. And I think you always bring proper context to an action as significant as this. And I too want to recognize the Community Solar Action Team and all the individuals involved with that. But today this is really, I think, a big decision for this commission, because this is one of the most substantial energy equity programs that's been passed by the legislature and implemented by our agency. We're standing on the shoulders of people like Senator Liz Stefanik's, Representative Patricia Raibal Caballero, and many, many stakeholders that are tuning in, that have participated and stayed engaged. And so I thought this was just a very robust, inclusive process, and I'm really proud of all of our progress to date on this important program. Before we go to a vote, Russell, can you just explain the next procedural steps regarding this rule and its implementation?
Yes, Mr. Chairman. The next step will be for the Office of General Counsel to submit the rule for publication in the New Mexico Register. I don't remember offhand what the submission date is for the next publication date, but it'll be fairly soon. And when it's published, which will be 15 days after that, whatever that submission date is, which I do not recall. That'll be the effective date of the rule. It's effective upon publication in the New Mexico Register.
Thank you, Russell. Okay, we have a motion and a second on the floor. Commissioner Fishman, any further discussion?
Oh, I guess I missed the second. I just wanted to be sure we had a second.
Any further discussion? Just to be clear, we did have a second on that, correct?
To tell you the truth, Mr. Chairman, I don't recall. I think we did actually, but I don't recall which commissioner it was.
Carl,
I
Carl?
believe it
maybe-
was, yeah.
It was seconded, Mr. Chair.
Thank you, Carl.
You're
Any
welcome.
further discussion?
Commissioner Fishman.
Russell, roll call vote, please.
Mr. Chairman,
Aye.
Commissioner Hall,
Aye.
Commissioner Basenti Aguilar,
Aye.
Commissioner Fishman,
Aye.
and Commissioner Byrd.
Aye.
Mr. Chairman, the vote is unanimous to approve the order and rule as revised with regard to the self-attestation provision.
Mr. Chair,
Yes, Commissioner Fishman.
just one final time, I wanted to say thank you to all the rest of the commissioners for the very collaborative way we worked through this today. I really appreciate it, and I think it really helps us come up with superior product.
Absolutely. Thank you. Thank you, Commissioner Fishman. Sorry, I didn't call for a bio break. I was so engaged in this discussion, but yes, Vice Chair Hall, were you about to say something?
No, I was just amused, but I guess you were so engaged, as we all were, we just didn't think about it. So it's kind of a good sign.
Right, let's go ahead and move on to communications with the Chief of Staff. What? No, I put it right before adjournment. Yeah. Well, it's afternoon. Good afternoon, Wayne.
Good afternoon, Mr. Chairman, Commissioner Byrd, and members of the commission. I realize I sit between you and lunch, so I will try to be brief. But I wanted you to know, Mr. Chairman, I did follow up on your suggestion that I meet with the Office of General Counsel regarding their staffing issues. They can, of course, give you their own feedback. I thought it was a very good meeting, a positive meeting. There's no doubt that we have some short-term challenges there. I think we addressed how perhaps we can deal with those. But the truth of the matter, Mr. Chairman, and members of the commission, is that OGC is understaffed, period. This isn't just a short-term problem. They need more attorneys in that office. And as I noted when we met last time, I've acknowledged that, and we are working to increase the staffing levels for that office. In particular, we've taken 2 non-attorney positions that have been vacant for a long period of time. One in the Office of General Counsel itself, but the other one in the Office of ASD. And we've reclassified those to an Attorney 3 position, which is currently under active recruitment. I believe OGC is beginning the process of interviews for that Attorney 3 position. The second position is an Attorney 2 position. That one will be hopefully ready for recruitment at the beginning of the fiscal year, July 1st. That doesn't sound like much, just 2 positions, but that would be a 30% increase in the staffing levels at OGC. And that's what needs to happen. It should have happened perhaps before. It didn't, doesn't really matter. But going forward, there's no doubt that the workload for the Office of General Counsel is not going to decrease. Again, I feel fairly comfortable in terms of the short term as well. They have a lot on their plate. We all know that, but in the discussions with them, I think they'll get us through the next couple of months. And then once the longer term solution of having additional staffing in place is dealt with, we won't have to worry as much about those 4 o'clock or 5 o'clock in the morning emails that you noted, Mr. Chairman. I don't want to see those either. I expect an honest day's work for an honest day's pay out of all of our employees. We owe that to the public. We owe that to you, the commission. But 4 and 5 o'clock in the morning emails are not healthy. I recognize that. I would say that we have other divisions that are probably sending emails at the same time. I want to acknowledge their work too. Our utilities division, as you know, Mr. Chairman, is also understaffed. John's been working very hard to address that with his bureau chiefs. I've tried to be as supportive as possible in terms of dealing with that as well. Our legal division, our ASD division, we have good people here and we want to keep them and we don't want them to leave because they don't have the staff and support to do their job. So a long report, Mr. Chairman, but I did want to let you know that I followed through on your request that I meet with OGC. Again, you feel free, as you always do, to discuss with them their perceptions of the meeting, but I thought it was useful to me as chief of staff, and hopefully we'll be on a better path going forward. And with that, Mr. Chairman, I'm happy to let you go to lunch or answer any questions or address any other issues you have.
Thank you, Wayne, and thank you for moving on that recommendation. Any questions for Wayne? Any questions?
Mr. Chairman.
Yes, Commissioner Vicente Aguilar.
Yes, I would like to know if the contract is still in place and do we still have the assistance of Carolyn Glick?
Mr. Chairman and Commissioners and Commissioner Vicente Aguilar, thank you for that question. I appreciate it. It is in place through the end of the current fiscal year. And in addition, one thing I didn't mention, in addition to creating those 2 new attorney positions in the Office of General Counsel, we've set aside $75,000 for the next fiscal year to continue contractual relations with an attorney. So the answer is it's in place for the current fiscal year, and we've significantly increased the amount that will be available to continue that arrangement into the new fiscal year.
Any other questions for? Yes, Commissioner.
Mr. Chairman, if I may.
Yes.
Chief of Staff Probst, I am hearing from you your deep concern and your aggressiveness to tackle what is needed for the commission. I am hearing that from you today. I've been waiting a very long time, and your report today is coming through as what I wanted to expect. Thank you so much, Chief of Staff Probst.
Thank you.
Thank you, Commissioner Vicente Aguilar. I guess I had a question on FY22 closeout. Will we be getting a status on potential reversions or a plan to fully obligate remaining funding for FY22?
Absolutely, Mr. Chairman and members of the commission, you will. When do you think we'll have a good idea?
Next week would be hard to plug in full. I'm out next week.
Good. So the answer is yes, Mr. Chairman. We'll do that as soon as possible. And we are trying as hard as we can to spend the funds that we've been appropriated for the current fiscal year. I can't promise we'll get to zero, but I think it's certainly something that is on my mind.
Well, we still have time for some bars, right, to move some money around, and we always have. No, okay, I don't see a note. Oh, okay, okay. All right, well, we'll wait for that presentation. I know you're on it. Anything else for Wayne?
Mr. Chair?
Yes, Commissioner Fishman.
While we may not have bars, we can still discuss the issue at a bar, just so you know.
Oh, look at you.
I'm just kidding. What can I say?
Mr. Chair,
Yes, Vice Chair Hall.
so I just had a question for Wayne. I was wondering where we are with the interviews that the Public Utility Fortnightly magazine wanted to do with this. The last I understood from you, our chairman was the only person who'd gotten his interview done, and I sent in my availability time, but I just wondered what's happening with that. If you could remind the commission of what our status is there.
Sure, Mr. Chair. Mr. Chairman, members of the commission, and Commissioner Hall, you're correct. The chairman is Johnny on the spot. He's completed his interview. I believe he did that on Monday. We have two other commissioners that we're in the process of trying to schedule. I think we can get that done. So I just say, Mr. Chairman, if members of the commission haven't given me a date or two when you would be available for about 30 minutes to do these interviews, I'd appreciate you doing that. I think we have a little bit more time, another couple of weeks. But in order for this article to be published, they don't want just 2 commissioners or 3 commissioners. They want the perspective of all commissioners. So it is important that we get those scheduled in the next week or 2. But we're making slow progress.
Okay, thank you very much.
And then on that, when I was interviewed, I didn't have an opportunity to talk about a group photo, but I noticed when they showcased the Florida Commission, they had a really nice photo on the cover. And so maybe Christopher or you, Wayne, can maybe inquire to see if we can get that arranged. And also, if for those of you commissioners who have not been interviewed, I looked at that issue and to get a glimpse of some of the questions, and it was very informative in terms of having an idea what they're going to ask you during the interview. They're pretty much all softballs, but I invite you to look at that fortnightly issue that showcased the Florida Commission. Anything else? Any other questions for Wayne? Thank you, Wayne. Appreciate that. All right, communications from General Counsel.
Yes, Mr. Chairman, Commissioners, following up on what the Chief of Staff just said, we do have interviews scheduled for next week for our Attorney 3 position, and we may expand our scope of advertising for that position as well. The Attorney 2 position, yes, is subject to a reclassification request from an ASD position, I believe. Or maybe this is for, anyway, that has not yet been submitted to SPO due to, it'll be submitted to SPO in the next fiscal year for budgetary reasons, but then we'll get on that. We're very grateful.
Yes, Russell, I need to talk about the revocation hearing.
Oh, yes, I was going to refer to you right after this, Judy. Yeah, all right. Yeah, I didn't forget. I just want to say we're very, very thankful to have Carolyn. We're very thankful that the contract was expanded. She's working on 2 very important appeals, and she is obviously a great, great person to have working on them. So, and then Judy does want to, I'll refer it over to Judy.
Yeah. Good afternoon, Commissioners. I don't want to belabor this point. We all know that next week is the revocation hearing, and it was scheduled and noticed at 9:30. The commission last week discussed a seminar that several commissioners were planning on attending in the morning on May 25th. And we also discussed postponing the meeting till, I believe it was 1:30. That being said, I'm asking if there might be 3 commissioners available to call in at 9:30 to either just convene the meeting and say it will be reconvened at 1:30 and we can have the revocation hearing at 1:30, or possibly to convene the meeting at 9:30 and have the revocation hearing then, which generally lasts about 15 minutes. So that's my question. Between those 2 choices, which 3 commissioners could call in at 9:30, and what do those 3 commissioners choose?
Mr. Chairman?
Yes, Commissioner Vicente Aguilar.
Yes, I'm available 9:30 next Wednesday, and I'm also in favor of conducting the not conducting, but to go ahead with the revocation hearing to be handled in the morning at 9:30. So I'm one vote for that. Thank you.
Thank you very much. Would there be another two?
Commissioner Byrd, I'm enrolled in the training, but Commissioner Byrd is not. So I am. Are there any other commissioners enrolled in that advanced rate making course?
I am enrolled.
Yeah.
Okay, well, I can break away from the class to initiate the hearing and then ask that we reconvene at, was it 1:30, I believe? So I can do that. So it'll be Commissioners Vicente Aguilar and Byrd and myself.
And we will just open up the meeting and then say we're going to reconvene and have the public hearing at 1:30. That's what I'm hearing? Is that
Yes.
correct? Okay.
Yes. So
We can do.
Okay.
Yes,
Anything
thank you
else
very
from-
much.
Anything
No.
else from OGC?
No.
Nope, that's it, Mr. Chairman.
All right, thank you. Any questions for OGC? Commissioners, any questions? All right, hearing none, let's move on. Communications with commissioners.
Mr. Chair.
Vice Chair Hall.
So I just wanted to follow on what Wayne was saying about the Public Utility Fortnightly. I really hope we can all get our interviews done because this magazine goes out nationwide and it's really read by a lot of other people, not just the other commissions, but people who work in the utility industry. And I just think it would be a really nice opportunity to showcase New Mexico because, for the 5.5 years I've been a commissioner, we've never been on it. And I don't think we've ever, I think they even said that, the guy I think said to me that Steve Mitnick, the editor, he said he didn't think he'd ever done an article on New Mexico. And I just think it would be really nice to showcase our state, especially when we're so busy getting so many things done. And not just to toot our individual horns, but I think it makes New Mexico look in the eyes of the country like a leader in renewables, which we are. So I think we should let that be known. So anyhow, I just want to encourage people, and also to Wayne's comment about how they question us. I've noticed that too. They do seem to, when they're talking to each individual commissioner, talk about what that commissioner is interested in. So it's really a nice showcase. So I just want to encourage everybody to get their interview scheduled, because what I understand is that they have to get their interviews done by the end of the month, or they won't be able to get it done. I don't know why, but maybe there are other, I have no idea why, but that's what I was told. So anyhow, and then there was another issue I wanted to bring up. I think we've discussed it before, but I was wanting to maybe propose some action, and that is the issue of the matter before the U.S. Commerce Agency, wherein there was a complaint filed by a provider of solar panels here in the United States, that there are violations being carried out by solar panel makers in Southeast Asia of the U.S. tariffs that have been imposed on China. And those violations involve including Chinese components in the products that are being made by these Southeast Asian countries and then shipped to the United States. So they're allowing China, by building their products that way, to avoid the tariffs that are imposed by the United States on China. And the problem is this has caused an incredible disruption in the solar industry. And there was an article in the journal last Thursday that detailed a lot of the impacts. And it's, the immediate effects in New Mexico are really alarming. There's been a tremendous amount of immediate cut of personnel, laying off of employees by companies like Array Technologies and Affordable Solar. And it's going to impact 70,000 jobs nationwide. And the problem is the Commerce Department won't make this decision until November or something on this matter. So there's already been a lot of activity in our state at the higher levels. I understand Senator Heinrich got a bipartisan letter sent from Congress to the president, and he also spoke to the energy secretary, and I believe the governor's office either signed a letter by themselves or sent one with other governors. But I just wanted to bring that up in case we felt like we wanted to sign a letter or join with other commissions to sign a letter or something to press for sooner action by the Commerce Department, because it's having a really hard impact on our state's economy and on our ability to see compliance with the goals of the Energy Transition Act. So I just wanted to mention that again. I think I mentioned it before, but I didn't have these details. And, if anybody would like to sign a letter coming from our commission to send to the president, or send to the rest of our congressional delegation to ask them to send a delegation letter, I just want to toss that out for the commission to consider.
Commissioner Fishman.
Yeah, Commissioner Hall. So this letter isn't asking for a specific policy decision. It's just asking for a quick decision to eliminate the uncertainty, correct?
Well, yes. I mean, I think we'd probably be going too far to say what we think they ought to do with tariff decision-making. That has to do with broader policy issues that go beyond our scope. Although, if they could come to some sort of quick resolution that would permit our country being able to receive Southeast Asian products, and, I don't, with or without Chinese parts, I guess, or maybe if there's a workaround in any way so that they end up not permitting China to violate the tariffs. I prefer that, of course, but I'm not sure we want to get into that territory.
So I would be very happy to sign on to a letter that asks for an expeditious decision.
Yeah.
And that's what I'd feel comfortable signing on to.
Yeah.
Yeah, I'm willing to co-sign if you want to draft it up, Vice Chair Hall.
Okay.
And maybe we can take action on it next week.
All right. So you want this to come just from the commission and go to, who do you want it to go to?
Well, I think it should go to the Biden administration, since it's the Commerce Department who is responsible for taking action. We can always copy our congressional delegation. They're on it. They're already taking action. So I think it ought to be direct to the presidential administration. That's my opinion.
Fine. Yeah.
Okay.
Anybody else want to sign on? Commissioner Byrd or Commissioner Vicente Aguilar? And I think it looks better if it comes from the whole commission. I'm sorry?
Commissioner Byrd said yes.
Oh, good.
Mr. Chairman,
Yes, Commissioner Vicente Aguilar.
I would like to sign on, but a few minutes ago, we heard from our chief of staff how the general counsel's office is just overworked. Is there any way that we can handle this letter outside of the general counsel's office? There's been a number of letters being sent to different agencies or different offices over the past few months, and I feel for the general counsel's office that they are overworked with request after request. So I'm wondering if someone can volunteer to assist Commissioner Hall.
Oh, great. I mean, we can handle it in our office, but I see Commissioner Fishman
I was
offering.
going to volunteer my assistant Robert to help out if you need him in
Super.
drafting this, Commissioner Hall.
Yep, my
Thank
office
you.
can help as well, Vice
Okay,
Chairman.
great. I'll circulate it then. Okay,
Okay.
thank you.
Vice Chair Hall, and thank you for your leadership, not only in this issue, but I guess cornering the managing editor of Fortnightly. So I think we have you to not blame, but to thank. So thank you for doing that.
Thank you.
All right, any other communications with commissioners?
Mr. Chair.
Yes, Commissioner Burt.
So now to the important part of the business after 4 hours of talking. I get to announce for the second year in a row that the Logan baseball team is the 1A state champion.
Excellent. Are you their coach? Commissioner Byrd?
No,
Oh.
occasional bus driver. That's all I get to say I had a part of.
Well, that's
That's why they're
essential.
so successful.
That's right.
Congratulations. Please give my congratulations to the team and the coach
Of course.
and the bus driver.
And can we each get a baseball signed by the team?
I will ask.
They're going places.
I would love to have that we got a commissioner who's a breeder of champions.
Well, anyway, thank you. I will ask. That's a good question.
Thank you, Commissioner Byrd. Any other? Yes, Commissioner Fishman.
Mr. Chair, I'd had John Olmsted do some work on what I'm calling a utility profile, which is kind of a brief piece of paper. I won't call it a piece of paper, a brief document that kind of sums up what each of our major utilities is all about in terms of service profiles, financials, how they're performing against renewable energy goals, and kind of puts it all into one place so that folks can get a quick picture and context of where each of our utilities are. And the proposal is that it's certainly something useful as a quick crib note for everyone throughout the organization, meaning the PRC, but also probably a good thing to post on our website so that the public has a good sense of this stuff. And I'd sent out kind of an initial draft just yesterday based on some of the research, excellent research that John did, asking for commissioner suggestions and comments on anything else that they think should be included. And would very much appreciate when you got a minute, I know everyone's really busy. If you have suggestions, please send them forward. And I want to be sure that the concerns of all commissioners are reflected in this profile. And that was
Thank
it.
you. Thank you, Commissioner Fishman. And as I suggested last week, at some point, I'd like to have a sub-agenda item under communications with commissioners to hear any updates from Commission Advisory Services Group members. But I don't want to put John on the spot yet, but let's at least fill this next position and then we can integrate updates from them as we go forward. So please take note, Isaac. All right, anything else? Any other communications from commissioners? All right, hearing none, let's move on to the next agenda item. It is an executive session to discuss personnel matters. We've had a long meeting. We have not had lunch. But what I really think we ought to do is come up with a plan to move forward on this process to fill the advisory economist position. My fear is the longer we wait, other opportunities may arise for these candidates and we could lose the opportunity of of hiring the best candidate that's applied so far. And the process as I understand it, is that we sent all applications to all commissioners. We asked HR to set up a table to indicate objectively which candidates kind of meet the minimum well, all the applicants were screened for meeting minimum qualifications. So there was a short list done by HR. Then HR developed a table that kind of indicated general experience in certain areas. HR asked us to rank them for the purposes of further shortlisting to conduct interviews. And that is where we're at, as I understand it. But at this point, I'm asking any commissioner who wants to step forward, Commissioner Vicente Aguilar, if you want to maybe, work with another commissioner, if that's the will of this commission, or we can just go to interviews. Let's just interview. I think there's 5 candidates right now, but we're going to have to establish set times to interview these candidates. And so what I suggest is that we forego having an executive session and just interview all of the 5 candidates that have met minimum qualifications. And we can have HR schedule them well in advance, probably this week. And that way we can have an executive session at the next meeting on Thursday, I believe, and conduct interviews in the afternoon, right after lunch. Is that acceptable? Are there any suggestions to moving forward with that?
Mr. Chair, I think Mr. Chair.
Yes, Vice Chair Hall.
I think it's the best way to go. I actually thought there were some weaknesses in that table that was created because I think the categories were not actually as comprehensive as they needed to be. So I think we should interview all of them. It sounds like there's a disparity of viewpoints. So we need to just interview them all. And I don't think it takes that much time. And I think it's an important position, especially for commissioners, to get the best advice. So we all ought to look at everybody.
Mr. Chairman.
Okay, yes, Commissioner Vicente Aguilar.
Yes, would it be possible to set up a time this coming Friday, 10 a.m.? We asked HR to establish a Zoom meeting for all commissioners and send out a possible quorum. Is that sufficient amount of time?
Mr. Chair, I have a conflict from noon to 1. Could we start earlier, like 8? How much time do we need? 2.5 hours? Like at 8 or 8:30? 8:30? If we could get done by 11.
Yes.
We started at 8.
8:30.
Maybe we need
Or
8
8:15.
because there's always a little time in between, If we started at 8, then we'd have a little cushion in between. So we could, or else we'd have to discuss at a different time among ourselves.
Let me just ask, what would be the goal of a Friday commission meeting to discuss this personnel matter?
To interview.
Mr. Chairman, it's to conduct interviews for all 5 commissioners with all the candidates. Maybe we can select 3 of them. I'm not too sure.
I still think
it's
that time frame for me it's just too short of a notice, and I think it probably is for the candidates as well. But if you want to have this executive session on a different date, I would suggest sometime next week. I think doing it in conjunction with the Wednesday meeting might be best. I can't make it on Friday.
Mr. Chair, I have a question. Why, in the past, we haven't done it in connection with an open meeting? We've just conducted the interviews. as we could schedule them. Is there some reason why we want to have it attached as an executive session to an open meeting?
No, no,
Well,
all I'm asking is that whatever we do, let's provide ample opportunities to schedule this, not only on the part of the candidates, but on our, given all of our schedules. And I want to make sure that we have a set of questions. I don't want this to be a kind of a free, wide open interview where we're asking different questions of different candidates. And so because I don't want a candidate to say, well, you know, there's no standardization in this interview to evaluate us based on standard questions. So believe I've asked through Christopher for HR to come up with some interview questions, and we can simply rotate the asking of those questions. We have questions? Okay. So we already have the questions, and we can rotate commissioners asking those questions as we go through different candidates.
Mr. Chair, could we circulate that list of questions? I mean, I think the commissioners need to look at what the questions are and add to it or criticize it or whatever, because I don't know who's written them and I don't know what they say. I'd like to at least see what the questions are.
What about, I mean, if you guys want to have it as a standalone meeting and just also offer ample public notification of the existence of a quorum, what about the 26th or the 27th?
Are you talking about having a public meeting to do the interviews in?
Well, we have to publish it as a notice of quorum, right? And
Yeah,
so
we do have to publish it. I
Mr. Chairman,
see.
could I provide some advice here?
yes, please.
Okay. Commissioner Hall, you had a good question about how some interviews have been conducted in executive closed sessions for open meetings and some haven't. And you may be able to help me pin this down, but my understanding is that we've done these interviews were scheduled to be by a quorum or the entire commission. And that's where the Open Meetings Act concern arises, because the Open Meetings Act requires that any action of not even action, any formulation of public policy, which OGC interprets very broadly, by a quorum or more of the commissioners, requires needs to be done in open meeting. Now, so there may have been interviews in the past where you had less than two commissioners may have interviewed a candidate, and that can be done outside of an open meeting. But it's questionable to do this kind, a full commission interview outside of an open meeting, especially because the Open Meetings Act actually refers to matters concerning hiring as being something subject to executive closed session, which means it's subject to the Open Meetings Act as formulation of public policy, even though it's internal. So it'd be safest to have this again during an open meeting. You could have a special open meeting for it, but yeah, it'd have to be a noticed open meeting if it's going to be all commissioners or a quorum of commissioners.
Russell, Mr. Chair.
Yes.
Commissioner Byrd.
Prior to Mr. Olmsted, we did have to notify that we were going to be in together, but they were not public meetings. They were not. We just did them in Chief of Staff's office. So,
Commissioner Byrd, that's a good, okay, I'm glad you clarified that for me. I'm going to need to speak to Michael about this, because I need to find out because I haven't dealt with many, I rarely deal with the employment matters. Michael has, and I have instructed the commission pursuant to Michael's instruction, notices of quorum don't actually solve Open Meetings Act issues. There's something that OGC has instituted, but if it's subject to the Open Meetings Act, holding it in an open meeting is what will address it, not a notice of quorum. But because this is not an area that I've dealt with very much, and I know Michael and some other members of OGC have, I will look into that. I can't answer your question right now. I wish I could.
Yeah, I understand.
Okay, so it has to be a noticed special open meeting if we don't have it in conjunction with a regular weekly meeting, correct?
That is, that's my interpretation of the Open Meetings Act. But as Commissioner Byrd is saying, perhaps if you have held them with the quorum of the commissioners before, and it's OGC has approved that with just a notice of quorum, I have to get clarity on that myself because I don't see how that would be compliant. But Michael may have reviewed this policy before. Again, I haven't handled many of these employment issues for OGC. My reading is it would be certainly safer to do it under the Open Meetings Act. And Michael has expressly told me in the recent past that a notice of quorum doesn't actually comply with the Open Meetings Act. It's just a notice it doesn't have much legal effect at all, really.
Okay, here's my suggestion. Let's schedule a special open meeting for Friday morning, not this Friday, but the following Friday at the same beginning time of 9:30. And in the executive session, it listed as we've listed in today's meeting, but I'd like to make the selection in the same meeting. I don't want to wait another week to make the selection. I think we've waited long enough. So let's schedule a special meeting next Friday. And it's going to be executive closed session with an open session action to make a selection following the closed session.
Okay. Thank you, Mr. Chairman.
Wait a second.
I believe we do. Yes, Vice Chair Hall and then Commissioner Fishman.
Well, one thing I was going to ask is, I hear you proposing it for the Friday following this Friday. That would be the 27th. And that's 10 days away roughly. I could be available earlier in the week too, say Monday or Tuesday. No, I can't. Never mind. Okay, never mind. We're in class. Okay. The other thing I wanted to mention was, so you want us to make our deliberations and about who to hire in public, because I think those could be made in the closed session as well, is my understanding.
No, only the decision to select would be done in open session.
That's what I'm talking about. Oh, you mean announce the decision after we've deliberated among ourselves in the closed session.
And
right?
we have to take action. We have to actually vote to hire whatever candidate we choose as a result of the interviews.
Right. Okay, fine. I'm fine with that.
And, look, I'm open. It could be Thursday morning and not Friday morning, but I just think everyone needs some advance notice here to schedule this and plan ahead. Commissioner Fishman.
Yeah, just a point of clarification. Is the intention to interview and select on Friday?
Yes, that'd be my preference.
Both together. Okay. Part of me kind of wants a day after interviews to sit on it, mostly because I guess I'm a muller. Sometimes things occur to me and it just, maybe it's my slow working mind, but having that day lets me get some perspective and at least for me, avoid some missteps, but others may not feel the same. So.
Well, we can do that. We can have the special meeting on the 27th and make the selection on June 1st. Because I don't think the meeting on the 25th, since we moved it to the afternoon, I don't think we're going to be able to accommodate a lengthy executive session. So
correct.
What if we go ahead and have the special meeting on Friday, the 27th? We'll make the selection at the subsequent meeting on June 1st.
Okay. Or if you like, we could do it on the 26th and then select on the 27th, if that fits your calendar. Just throwing out an option.
That works for me too.
Me too.
Any objections to that? Commissioner Vicente Aguilar.
Mr. Chairman, just a reminder, open meeting is canceled for June 1st.
Right.
That's on the calendar. We voted on it already.
Yep.
Oh, yeah.
I think Commissioner Fishman has a good proposal, which is do the interview on the 26th, 8 o'clock in the morning, and then make the selection on the 27th. Is that okay?
It's fine with me. Are there any objections to that?
Mr. Chair, no. So that means we'd have to have a special meeting on the 27th to announce and vote on our selection.
Yes.
And Mr. Chairman, you could have a special open meeting, the one that you have the interviews on Thursday, and then, just adjourn it until the next day. It could be the same special meeting.
Continue it to the next day. Is that what you said, Russell?
Yes, I believe so. Yes.
Okay.
I like that.
Everybody knows as one.
Let's see what's going on.
You guys are still thinking despite being hangry and hungry and. All right, any objections? So the plan is we're actually going to schedule a meeting for the 26th to conduct interviews, and then we'll recess and reconvene the next day to make a selection.
So what time are we meeting each morning?
I mean, I like 9:30. I think 9:30 just for consistency's sake, but if you want to move it up, that's fine with me.
I prefer to do it a little earlier if we could, just because I have other appointments later in the day. I've got one at 11, I've got one at 4, but I can work around some of it, but I'd like to get it done earlier if we can.
So 8 a.m. on Thursday, the 26th, 8 a.m. start.
Oh, let me see.
And then we can always,
Thursday, that's not so critical for me. I don't mind 9 on Thursday or 9:30, but Friday. Okay, you know what? Yeah, 9:30 on Thursday is fine. Friday, I have a conflict at 11 a.m. But we won't have a very long meeting on Friday at all. So that probably would also work at 9:30, I believe. Because we will have made our decision. Right?
one of the candidates is not available on the 26th.
Okay. Now what? Are they available on the 27th?
Well, we can always do that. We can interview whoever's available on the 26th and then complete the final interview on the 27th
That
and
works
make
for
the
me.
selection on the 27th.
That's still
That
rushed though. That
Well,
doesn't.
We'd have to move it to 8 o'clock. We'd have to move it earlier to do that.
Yeah.
On Friday, which I'm fine with.
Yeah. Or, I don't see why we can't have a series of special meetings if we need to interview other people earlier than that. I mean, if somebody's available earlier, I don't see why not have them come in earlier. If I were waiting for an interview, I'd like it as soon as possible. For my purposes, I don't need to push out the interviews. I don't need a week to wait to interview people. Do we want to start those interviews sooner than next?
Well, my recommendation is that we start earlier on Thursday because that'll represent the lion's share of the interviews. And that we could maybe start a little later on Friday to, wrap up, do one more interview. And keep in mind, we can still recess on Friday, right, for later on in the day to give commissioners an opportunity to look at all their scores and the answers that the candidates provided during the interviews and then make a decision.
Yeah.
Let's not overthink this. I think we're honing in on the 26th and 27th. We will work with OGC to schedule this out, but we'll make sure and coordinate with all the commissioners to make sure it works, not just for the candidates, but for the full commission.
Okay, let me ask one more question. Do we have a very long agenda on the 25th? Do we know yet that because the class that we're in ends at noon, I believe, or 12:30. And, if we don't have a real short, if we don't have a real long agenda, maybe we could interview whoever is not available on Thursday, maybe we could interview them on Wednesday.
I just think there's too much uncertainty. I mean, I thought we were going to end prior to noon today and it's almost 2 o'clock. So let's not leave that up for chance. Let's just go ahead and go with the 26th and 27th.
Yeah. Okay.
Okay, any objections to that?
No.
All right, thank you all. Anything else for the good of the order? All right, you've been very patient, very good. We are adjourned. Go get something to eat.